All right, we're on the record. This is in regard to the motion this morning to either allow or deny admission of Mr. Hall's question and answer statement given on an earlier occasion. I've had a chance to review the transcript of that as well as case law. And first of all, denying the defense motion to have the prosecution give an offer of proof or an explanation for why they are not granting immunity. I think even as the super case cited by the defense notes, immunity, the grant of immunity is strictly an executive branch function. It's not really subject to judicial review. And so regardless of what the state's reason was for refusing to give immunity to Mr. Hall, it's not reviewable by this court. So the request that the state provide a reason for not granting use immunity is denied. With regard to the statement given by Mr. Hall, and this assumes that he is not going to be answering any questions, even if I order him to do so, I'm going to find that none of the statements in the question and answer statement are admissible. First of all, in Johnson versus Fabian, that noted the basic standard for a Fifth Amendment claim and how broad it is, and it tends to be much broader than 804b3. Under the Fifth Amendment, answers that would in themselves support a conviction or that would furnish a link in the chain of evidence needed to prosecute the claimant are incriminating for purposes of the privilege. And in fact, in discussing that, that was from Johnson versus Fabian, which is 735 Northwest 2nd, 295, which was cited by the state. They also note that the privilege allows an individual to refuse to answer official questions put to him in any other proceeding, civil or criminal, formal or informal, where the answers might incriminate him in future criminal proceedings. That standard is obviously fairly broad. And so if it might incriminate the defendant or provide a link to other evidence that might incriminate, the invocation of the Fifth Amendment privilege is appropriate. In contrast, 804b3 states, in part, pertinent part states, a statement which was at the time of its making so far tended to subject the declarant to civil or criminal liability that a reasonable person in the declarant's position would not have made the statement unless believing it to be true. In other words, if somebody goes into the police department and confesses to a murder, generally people don't do that because, unless it's true, because it so clearly tends to subject the declarant to criminal liability. And that is judged from the time of the statement's making. And the statements that are contained in the question and answer statement are in fact not the type that would clearly be so far contrary to the declarant's penal interest or subject that person to criminal liability that they would not make them unless true. Most importantly, for example, Mr. Hill totally denies providing controlled substances to George Floyd. He talks about how he was appearing tired and all that, but the entire statement seems to be Mr. Hall describing what does not incriminate him. He's willing to do that, but when it comes to anything that he might have done, he denies engaging in any activity like dealing. There are some sporadic references to dealing on the street, but there's nothing specific as to time, date, location, persons involved that the person would be subjecting themselves clearly to criminal liability. Accordingly, it does not fall under 804b3. Under 807, a statement not specifically covered by Rule 803 or 804 may be admitted, but it must have equivalent circumstantial guarantees of trustworthiness. I see nothing internally within the question and answer statement that Mr. Hall's statements had any guarantees of trustworthiness, and accordingly, it is not admissible under the rule for that reason. The defense does have a right to a complete defense, but since there are witnesses who can testify as to what, and have testified as what Mr. Floyd looked like at the time. I don't think that the rules of evidence must give way completely to any claim of this evidence is necessary for a complete defense. I find it is not, and accordingly it is not admissible. Any questions about that ruling from the state or from the defense? All right. We have other housekeeping things, but we'll handle those after the jury. Unless you wanted to take care of some of those now, we can do that after, because we're going to be done before 4 o'clock. Is that correct? All right. Why don't we deal with the housekeeping things and that afterwards? All right. We'll be in recess until jury's ready. Maybe we can get them out maybe in 5 minutes. Will your witnesses be available? All right. Let's look at reconvening in 5 minutes. State may call as the next witness.
Thank you, Your Honor. The state calls Phalonis Floyd.
Hold on. Hold on. You can wait out in the hallway just for a second. Council sidebar. All right. Raise your hand, please. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
Yes.
And sir, if you would feel comfortable doing so, if you could remove your mask, that'd be great. And we're going to test out the microphone. First, have you state your full name, spelling each of your names.
Phalonis O'Neal Floyd, Philonise, O'Neal, Oneil, Floyd, Floyd.
Mr. Swisher.
Thank you very much, Your Honor. Good afternoon.
Good afternoon.
Sir, you're here to testify about your brother, George Floyd. Is that right?
Yes, sir.
And before you tell the jury about your brother, I'd like you to introduce yourself to the jury a little bit so they know something about you. How old are you?
39.
Was George your older or younger brother?
He was my oldest brother.
Are you married?
Yes, sir.
And do you have children?
Yes, sir.
How many children do you have?
2.
And sir, what state do you live in?
Houston, Texas.
I'd like you to tell the jury a little bit about your brother, George Floyd. First, can you tell the jury where and when he was born?
He was born in Fayetteville, North Carolina, but he left at a young age. We moved to Houston, Texas, and I have 2 other sisters that are older than us. It's Jaja Latonya Floyd, then became George Floyd, ex Phalonis Floyd, and my other brother Rodney Floyd, who's mom's baby boy.
All right.
Mhm.
And was he born on October 14, 1973?
Yes, sir.
And you say that the family left Fayetteville shortly after he was born. Is that right?
Yes, sir.
And you all grew up in Houston together.
We all grew up in Houston.
Who were George's parents?
Lacenia Jones Floyd, and his father was George Perry Floyd Sr.
And did Lacenia, is that your mother?
That's my mother, but they called her Miss Sissy.
Miss Sissy.
Yes, sir.
Who called her Miss Sissy?
Everybody called her Miss Sissy. We just called her Mom, but everybody around the neighborhood called her Miss Sissy. Anybody that knew her called her that, and that was that. They had to be like 50 years of age, but everybody younger than that called her Mom. That was George's age. Everybody called her Mom because she was a mom to so many people in the community.
What community was that?
That was in 3rd Ward, and I grew up in the CUNY Home Housing Authority projects. It was low income poverty. So we stayed with each other all the time. Me and George, we grew up together playing video games a lot. His favorite game was on Nintendo. we played double dribble, and we played Tecmo Bowl. And I finally beat him in a game, and I was just so happy just thinking about that. And he reset the game and would say, "Come on, let's play again." And I'd be like, "No, I gotta go do our chores now. Let me do my chores." But George also, he used to make the best banana mayonnaise sandwiches, and he used to make syrup sandwiches because George couldn't cook, he couldn't boil water. So, and also if you all were there in our house, you'll see George had lines on the wall because he will always measure with his height, trying to see how tall he is because he wanted to be taller all the time because he loved sports. So he always wanted to be the best. And
Sir, I'm going to interrupt you for a moment. I appreciate you sharing that with us.
mhm.
Uh, I'd like to show the witness what's been marked for identification as Exhibit 284. Do you recognize the picture in 284?
Yes, sir.
Is that a picture of your mother and George when he was younger?
Yes, sir.
I'm going to offer Exhibit 284.
Any objection? 284 is received.
Permission to publish. Sir, would you please describe this photo and what you know about it?
That's that's my mother. She's no longer with us right now, but that's that's my oldest brother, George. I miss both of them. They are. I was married in May 24th. I got married, and my brother was killed May 25th, and my mom died on May 30th. So it's like a bittersweet month because I'm supposed to be happy when that month comes.
Sir, I'm going to ask you some questions about your mom's passing a little bit. If you need a moment, I can take a minute and just let me know when you're ready. Oh, going back to growing up in the CUNY homes, can you please tell the jury what role George Floyd had as the older brother in that household?
He was so much of a leader to us in the household. He would always make sure that we had our clothes for school. He made sure that we all were going to be to school on time. And like I told you, George couldn't cook, but he'll make sure you have a snack or something to get in the morning. But he was one of those people in the community that when they had church outside, people would attend church just because he was there. Nobody would go out there until they seen him. And he just was like a person that everybody loved around the community. He just knew how to make people feel better.
And sir, you indicated, well, first you aware of where George Floyd went to school.
He went to school at Blackshear Elementary, and from Blackshear it was Ryan Middle School, and from Ryan it was Jack Yates High School, where he excelled in sports and basketball and football. He was he had received a scholarship to attend South Florida College, and from there he played basketball there, and he transferred to Texas A&M Kingsville, where he played football.
All right. Now, I'd like to show the witness Exhibit 285 for identification. Sir, do you recognize what's shown in Exhibit 285?
Yes, sir.
Is that a picture of your brother when he was at the Jack Yates High School in Houston?
Yes, sir.
Offer Exhibit 285
Any objection? 285 is received.
and permission to publish. Approximately how old would George Floyd have been when this picture was taken?
It's like it looked like 18 or 17 at that time.
And you talked about basketball and playing basketball. If I can show Exhibit 287 to the witness. 287. Thank you. All right, showing you what's been marked for identification as Exhibit 287. Do you recognize this photo?
Yes, sir.
Is there a picture of your brother in this photo?
Yeah, he's number 5, South Florida, all the way in the left-hand corner.
All right, I'm going to offer Exhibit 287
Any objection? 287 is received.
and permission to publish. All right, you indicated that your brother was number 5. Is it on the far
Yes.
left?
Yes, sir.
And South Florida, was that a community college?
South Florida was a community college. I'm looking at it. I noticed a whole bunch of the ball players because I met a lot of them coming up.
Did George Floyd maintain his level of fitness and love of basketball throughout his life?
Yes, sir. He loved to work out. He loved playing basketball. He loved teaching people the game of basketball. That's to me where I really learned how to play from him because he guided a lot of guys on the court, showed them what they need to do to be better.
And when he would talk about playing basketball, would he use any particular term or phrase?
Oh, he said, "Hey, man, let's go hooping," and we will always say, "Come on, let's go." We always went hooping, and you have to hoop every day because if you don't go and shoot a whole bunch of shots, like 50 to 100 shots a day, my brother will always say, "You'll never be able to compete." Hooping was big because Magic, you had to watch the stars. We watched Michael, we watched Magic, we watched everybody hoop every day.
And if you could take that down, you indicated that George Floyd was also interested in football or had a passion for football. Is that right?
Yes, sir.
Would he play catch with you?
He would play catch with us. It's funny how I always thought that my brother couldn't throw, but he never intended to throw the ball to me. He will always throw it at an angle where I have to go chase it and jump for it or dive for it. And I came up to him one day. I said, "Man," I said, "I see why you play tight end and stuff because you can't throw it all." And he was like, "I don't want to throw the ball to you because if I throw it to you, you'll never understand. You have to go get the ball." He said, "The ball should never come to you. You should always tell yourself, I'm going to go get the football because you have to attack the ball." That's what he told me.
Sir, was your brother a father?
Yes, sir.
I'm going to show you what's been marked for identification as Exhibit 290, just to the witness. Do you recognize what's shown in Exhibit 290?
Yes, sir.
Is that a picture of your brother with his daughter?
Yes, sir.
Offer Exhibit 290
Any objection? 290 is received.
and permission to publish. And what's his daughter's name?
Gianna,
And how old is she now?
7.
Sir, could you please, for the jury, describe George Floyd's relationship with his mother?
Oh, it was one of a kind. George, he would always be up on our mom. He was a big mama's boy. I cry a lot, but George, he loved his mom. He will always just be up on her. And, every mother loves all of her kids, but it was so unique how they were with each other. He would lay up on her in the fetus position like he was still in a womb. I would see him every day and I'd say, "Period." I'd say period because we called him Perry instead of George. And he would always say, "Hold on, let me kiss mama before I come over there." And being around him, he showed us like how to treat our mom and how to respect our mom. He loved her so dearly. And when George he had found out that my mom was passing because she had to stay with us for hospice, and he was talking to her over the phone, but she perished before he even came down here. So that right there, it hurt him a lot. And when we went to the funeral, it's just George just sat there at the casket over and over again. He would just say, "Mama, mama," over and over again. And I didn't know what to tell him because I was in pain too. We all were hurting. And he was just kissing her and just kissing her. He didn't want to leave the casket. And everybody was like, come on, come on, it's gonna be okay. But it was just difficult because no, I don't know who can take that when you watch your mother, somebody who loved and cherished you and nourished you for your entire life, and then they have to leave you. We all have to go through it, but it's difficult. And George, he was just in pain the entire time.
Sir, you indicated your mother passed away May 30. That was 2018. Is that right?
Yes, sir.
And you described seeing your brother George at the funeral. Is that right?
Yes, sir.
And was around the time of your mother's passing the last time you saw your brother George Floyd in person alive?
Yes, sir.
Did you maintain contact with him on the phone, through text and whatnot after that?
Yeah, we text, we called each other. He would call and I would call him, but we would talk a lot of times early in the morning because I was a truck driver. So he will always be up talking to me and getting pointers on how to back up, how to do this, shifting gears, different things like that. And I had great teachers, so I would also just explain to him what he needed to do. And that level to get to that next tier, that's what he would do. He would just listen. And he became a student. And I always had to ask him for advice because it was my big brother.
Sir, and this is a yes or no question. Were you informed that your brother George Floyd died on May 26, 2020?
Yes, sir.
Thank you very much. I have no further questions, Your Honor.
Any questions?
No, Your Honor, I have no questions.
All right, thank you. Thank you, sir. Thank you for being here. And the next witness, please.
Let me make sure he's here, Your Honor. Is he here? Yeah. Thank you. Your Honor, the state calls Seth Stoughton.
Raise your right hand, please. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
I do.
Let's see, please.
Thank you.
And if you could remove your mask if you're comfortable doing so.
Yes, sir.
And let's begin by having you state your full name, spelling each of your names.
My name is Seth Wayne Stoughton, SETHWANESTOUGHTON.
Mr. Slisher.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Sir, how are you employed?
I am an associate professor at the University of South Carolina School of Law and an affiliate professor in the Department of Criminology and Criminal Justice.
How long have you been a law professor?
I've been there for 7 years now, almost 7 years, and 2 years prior to that in a teaching fellowship preparing to be a law professor.
Okay. And do you teach academic courses at the South Carolina Law School?
I do.
What courses do you teach?
I teach criminal law, criminal procedure, a regulation of vice seminar, and police law and policy.
Do you also conduct any scholarly research?
I do, yes.
What scholarly research do you conduct?
I study the regulation of policing and multiple aspects of the regulation of policing.
Okay. Now, I'd like you to please describe your educational background to the jury so they can understand how you come to be a law professor at the University of South Carolina. First, where did you receive your undergraduate education?
Florida State University in Tallahassee.
And what was your degree?
English with a focus in literature.
And before we get into your law career, have you always been in academia?
No, I have not.
What was your prior career before becoming involved in academia?
I interrupted my undergraduate education to take a job as a police officer with the Tallahassee Police Department, and then later as an investigator with the Florida Department of Education's Office of Inspector General.
I'd like you to please describe for the jury your experience as an officer with the Tallahassee Police Department. First, what year did you join the department?
I applied to the department in 2000 and was employed in early 2001.
Can you describe for the jury the training process that you went through to become a police officer in the state of Florida?
Sure. So Florida has a academy requirement. I went to a regional police academy, which means not an academy run by my particular agency, but instead an academy that trains officers from a number of agencies in North Florida. After finishing the approximately 5.5 months or so of academy training, I went through additional pre-service training at my agency, about a month of classroom training and additional sort of lecture style training and hands-on training, and then went through 3.5 months of a field training program.
And after you completed your field training, you received an assignment as a law enforcement officer in Tallahassee.
Yes, I did.
I'd like you to please describe for the jury at kind of a high level the different assignments you had as a police officer with that department.
I was there full-time for just under 5 years. The entire time I was there, I worked on patrol. That was our uniformed capacity officers who are responding to calls for service or pulling over vehicles and the like. I had some additional assignments as a patrol officer. I spent about 2 years on our special response team. I taught community self-defense classes and child abduction and molestation prevention classes in the community and the like.
And as a patrol officer, were you ever in a situation where you had to use force on an individual?
Yes.
You ever have to arrest somebody?
Yes.
Handcuff a reluctant subject?
Yes.
Something that you would routinely do as a police officer?
Yes.
Did you respond to calls for service and write police reports?
Yes. Lots of calls for service and lots of reports.
After you left the Tallahassee Police Department, you took a job was it the Department of Education?
Yes, Florida's Department of Education as an investigator in their Inspector General's office.
Please describe your general duties there.
So as an investigator, I was charged with investigating waste, fraud, and abuse within and affecting the Department of Education. The investigations were both administrative, for example, sexual harassment allegations within the Department of Education, and also criminal, private school tuition voucher fraud primarily, although there were some other non-tuition voucher fraud criminal cases that I was involved in.
When did you decide to go to law school and enter law school?
Having put my undergraduate education on hold, as an investigator, I now had a regular day job, so I was able to finish that degree. It took me 10 years to get a 4-year degree because I can be a little slower than the average bear sometimes. As I was coming up on the end of that degree, we made the decision, my wife and I made the decision to go to law school to continue to expand career options.
Where did you attend law school?
The University of Virginia.
And what year did you graduate from law school?
2011.
And at what point did you enter academia generally?
I clerked for a year after law school. I worked for a federal judge based out of Indiana for the year after law school. I then began my academic fellowship after that clerkship.
And in your academic pursuits, did you decided to build on the experience that you had as a former police officer?
Yes.
How so?
As I began law school, I really had no intention of becoming an academic. And I had some outstanding professors, and between their influence And my interest in studying policing from an academic and a legal perspective, I realized there was a little bit of a niche where I could draw on some of the information that I had from firsthand experience to either ask questions that other academics maybe had not asked, or to find answers in different places that other academics may not have thought to look.
And is that where you've focused your research?
Yes, all of my research has been on policing and the regulation of policing.
Have you authored any scholarly publications?
Yes.
And what sort of publications have you authored?
I have written law review articles, which is the type of academic journal that legal scholars publish in. I've written for a number of different publishers, a number of different articles on a range of topics, officers and off-duty employment, the use of force, tactics, different ways that aspects of our legal system regulate police officers and affect officer behaviors.
Have you authored chapters of books?
Yes, I have.
What books, what publications have you authored chapters of?
I think my most recent publication was in Critical Issues in Policing, which is a series of contemporary essays on policing. That chapter is on the regulation of police violence. I've authored book chapters on police misconduct, and I'm authoring another one on use of force review right now.
You published a book recently, is that right? You co-authored a book, is that right?
Yes, I did.
And what's the title of the book?
That's Evaluating Police Uses of Force.
All right. You have a copy with you here.
I do.
You co-authored that book with Jeffrey Noble and Jeffrey Alpert, is that right?
Yes, that's correct.
So are you a member of any professional organizations?
I am, yes.
What professional organizations are you a member of?
I'm an associate member of the Virginia Bar, which is a non-practicing member of the State Bar Association for attorneys. I'm a member of the American Society of Evidence-Based Policing, a member of the International Association of Chiefs of Police. I serve as an advisor to the American Law Institute's Principles of the Law on Policing. I'm a member, or I believe technically a liaison, to the American Bar Association's working group on trust in the criminal justice system. There are probably a couple of other ones. I don't remember them all offhand.
Do you occasionally provide consultation to law enforcement agencies in conducting use of force reviews through these organizations?
Not through the professional organizations, but I do work with, consult or do research with police agencies, yes.
Does that include providing educational instruction?
Yes.
Consultation?
Yes, it has.
And specific use of force reviews?
It has, yes.
And what agencies have you done that kind of work with?
I've done training and presentation to the training officers in the Richland County Sheriff's Office, which is, I believe, the largest law enforcement agency in South Carolina. I'm a member of the Civilian Advisory Council with my local police department, the Columbia Police Department. So I sit in what are called command review boards, which can involve assessing use of force in that context. I've done presentations and training at the Federal Law Enforcement Training Center, which is not an agency per se, but the audience had representatives of a number of different state, local, and federal agencies. I've provided training and presentations to the Bureau of Alcohol, Tobacco, Firearms, and Explosives senior staff, to the command staff of the Kansas City, Missouri Police Department. All of those are sort of formal. There might be a couple of others, as well as a range of informal consultations and discussions on a range of issues with a number of agencies.
And are you a frequent speaker or lecturer on issues of policing and uses of force throughout the country?
Yes, although in the past year, most of those have been presentations from my home via Zoom, but yes, they're based all over the place.
What organizations do you present to?
I've presented well over 100 times at this point to organizations that include the American Judges Association, the Conference of Chief Justices, judicial conferences in a number of states, prosecution or defense conferences in a number of states, security conference in Mexico City, a prosecution and defense combined conference in Canada. Most recently, I've presented at several law reviews and symposiums, one hosted by the University of, by Loyola University in Chicago. That was this past week by the Journal of Criminal Law and Criminology. That was the week before, I believe, by the University of Wisconsin, Plattsville. That was also in this past week.
Right. Have you previously been retained as an expert witness?
Yes, I have.
How often have you been retained as an expert witness?
I've been retained around 60 times at this point.
Okay. Have you testified as an expert witness before at a deposition?
Yes, I have.
Okay. Approximately how many times?
At deposition, I think over a dozen, pretty easily at this point, I believe.
And in those depositions, have you testified as an expert witness in the area of use of force?
Yes, tactics, use of force, police procedure, yes.
Have you testified at a trial before as an expert in the use of force?
Yes, I have. Use of force, including tactics and use of force related issues, yes.
What courts have you testified in?
There was a federal court in North Carolina, a federal court in South Carolina, criminal court in Georgia. I think that's it for trial testimony. As you know, most of these, most cases don't actually make it to a trial. Yep.
And you were talking about depositions. Those are civil cases, is that right?
Yes, that's correct.
All right. Now, you've been retained in this matter to provide testimony regarding the use of force that occurred on May 25, 2020 in the matter of the death of George Floyd. Is that correct?
Yes, I have.
Okay. And having been retained, you charge a fee for your services?
For my time in review, yes.
All right. What is your fee, your hourly rate?
$295 an hour in this case.
And you receive a different rate for trial days?
I have a 8-hour minimum on days I'm expected to testify, yes.
Okay. And to date, how much have you been compensated based on your work in this case?
I would have to look at my records to see what actual compensation has been. In the area of maybe $24,000 or $25,000 received.
How many hours would you estimate that you've put into preparing for this matter?
Including both compensated and uncompensated hours, I'm probably in this might be overestimating slightly, but in the 130 to 140 hour range.
You know, in your experience as an expert witness, have you always reached a conclusion that's favorable to the party who hires you?
No.
Why is that?
Because the facts and my review of the facts did not favor them. So my credibility is very important to me. And if I am retained and develop an opinion that does not favor the attorney who retains me, that's still my opinion.
Now, did you actively seek to participate in this matter?
No,
Who contacted you?
the state of Minnesota.
Based upon in your retention with the state of Minnesota, have you developed opinions regarding the use of force against George Floyd on the date of his death?
Yes, and related activity, yes.
I'd like you to please explain to the jury first the process by which you go about reaching conclusions, analyzing cases such as this.
Sure. So the first step is to get and go through the material. In this case, I believe I got an external hard drive that had tens of thousands of pages of documentation. I believe close to or over 40,000 pages of documentation, a large number of videos, including a number of body-worn camera videos, including the body-worn camera videos of the officers who were involved in this particular incident.
Those would include the body-worn camera videos of the defendant, is that right?
Yes.
And Officer Tao, Officer King, and Officer Lane.
Yes.
Did you also review some bystander videos, Darnella Frazier, for example?
Yes. Her video, Ms. Hansen's video, a video taken from across the street by a bystander, I think in a Speedway gas station. A traffic cam or a pole camera mounted somewhere up above. Yes, a number of videos.
As an individual who frequently reviews uses of force, are you commonly called upon to review body-worn camera footage and other footage such as surveillance or bystander video?
Yes. In fact, one of my academic publications is specifically about body-worn cameras, and I've done a great deal of both research and teaching on using video footage, interpreting video footage, especially in use of force cases.
If you could please describe to the jury just I guess the depth of body-worn camera footage you were able to view in this case as compared to one in which you might have just a single recording.
Yeah, sure. It's pretty common for a use of force to only involve an officer or two, to involve very limited video, maybe only the video from that particular officer. And body-worn camera or any video footage is just one more piece of evidence that I, in conducting a review, have to examine and weigh and measure against other pieces of evidence. In this case, unlike the vast majority of cases that I've been involved in, there were a whole bunch of videos. So videos from different perspectives of the same event that can allow a much more robust understanding of what was going on. To put it very simply, one camera only captures what's available on that camera. So I don't see what's happening off camera. But when I have multiple videos from multiple perspectives, multiple angles, it allows me to get a much better sense of what's happening when and where.
So using some examples, you examined the Frazier video, is that right?
Yes.
And you were also able to view the Alicia Finari, the Speedway employee's video as well, correct?
Yes, that's correct.
And then at the same time, view the Milestone video, the larger overview.
Yes, that's the pole camera video, I think on top or near the top of the Speedway.
And can you describe to the jury the different perspectives that you were able to see using each of those videos and how the viewing of one aided the understanding of the other?
Sure. So very simply, the Ms. Frazier's video was taken from the sidewalk near the squad, near the police vehicle. And you really don't see Officers Lane or King on that video. On the other hand, from the perspective across the street at the Speedway or the pole camera, you do see those officers. It's simply because the camera isn't obstructed by the police vehicle.
Now, did you, upon your review of all the videos, the documents that you discussed, complete a report memorializing your findings?
Yes, I did. My findings and opinions.
About how long was that report?
The report total, I believe, was close to 300 pages. That includes a rather lengthy appendix that lists out all of the materials that I reviewed. The body of the report itself, which has my summary of the relevant facts and my opinions, was, I think, about 112 pages. 110 pages if we take out the table of contents, maybe over 100 pages.
All right. And did you rely on your training and your experience and academic experience to review the evidence in this case and reach your conclusions?
Yes.
And have you reached your opinions to a degree of reasonable professional certainty based on generally accepted standards in your field?
Yes, I have.
Now, before sharing those opinions, sir, I would like you to please explain what factors you review when you're evaluating uses of force.
Sure. So first, as sort of a threshold point, I have to know what I'm actually looking at, right? I have to know which uses of force I'm actually reviewing. For example, if an officer is involved in a shooting, the saying is the officer has to account for every bullet that they put downrange. That is, they count as separate uses of force. After I identify what the uses of force are, then I apply essentially a four-step analytical framework. First, I identify what the relevant facts and circumstances are as viewed through the lens of a reasonable officer on the scene. Then I assess the threat, if any, presented by the individual's actions. Then I assess the foreseeable effects of the officer's use of force. And then the fourth step is sort of putting all of that together and assessing whether, in light of the facts and circumstances, the foreseeable effects of the officer's use of force were justified and reasonable because they were proportional and appropriate in light of the threat presented by the individual's actions.
By what standard are you making this assessment?
So the ultimate analytical question, that step 4, is applying generally accepted police practices, what we might call a national or professional standard for the way we expect and the way policing expects officers to engage with individuals and use force.
And what are these national standards based on?
So a combination of things. They're certainly influenced by constitutional law, for example, by history and research in policing. Since the 1970s or so, there's been tactical research within policing that's helped inform what we would now consider generally accepted practices, a great deal of evidence and experience as well.
Are there constitutional standards as well?
Yes, constitutional law, especially the Fourth Amendment standard, is one of the factors that defines or certainly influences generally accepted practices.
Is another influence a particular department's policies and training?
An agency's policies or training might, and indeed I would hope they are, reflective of the generally accepted practices, but we can't define industry-wide generally accepted practices by looking at a particular agency's policies or training.
So the standard you're reviewing is that of reasonableness.
That's correct. Now, we might look at a large number of agencies and say, okay, if hundreds or many, many police agencies are doing this thing, then maybe that's a best practice or a generally accepted practice. But you can't just look at one agency and say it's reasonable because this one agency said it was reasonable.
All right. When discussing the constitutional standards, you're familiar with the standards set forth in Graham versus Connor?
I am, yes.
And you have a demonstrative, I believe it's Exhibit 954. And if I could publish that, the Graham factors.
Okay. 954 is received for demonstrative purposes only.
Right. And can you just please tell the jury what it is you see here?
So this is a summary of what are referred to as the Graham factors. These are specific factors identified by the Supreme Court in the case Graham v. Connor that we use really in that second phase of analysis. And the second step, remember, is assessing the threat presented by the individual's actions. And to understand Graham v. Connor, kind of have to understand what we mean by threat. First, when we're talking about the threat that an individual may present, it's not some abstract notion. It's not general threat or conceptual. It's specific threat of something, right? Someone who's running away may present a threat of escape or a threat of assaulting an officer or the like. And further, we can define threat. We know that threat exists when the individual has the physical ability and the opportunity and the inherent intention to cause whatever specific harm we're analyzing. So, for example, imagine someone who's just standing there with nothing in their hands. They don't have the physical ability to hit an officer with a tire iron. So there's no threat that an officer is going to be hit with a tire iron. There's just no physical ability there. On the other hand, imagine someone who has a tire iron, but who's 50 feet away. They have the physical ability because they have a tire iron, but they don't have any opportunity. They're too far away in that moment to actually present a threat. And then we could imagine someone who has a tire iron and they're 2 or 3 feet away from an officer, but they're changing a tire at the time. They have the ability and the opportunity, but there's nothing about that interaction, as the officer's talking with them, that suggests they have the apparent intention to cause that particular threat. So when you put all of those three things together, ability, opportunity, and intention, that's how we identify threat. The Graham-Connor...
I'd like you to contrast that with risk.
Oh, sure. So threat, as I've defined it, can be contrasted with risk. Risk you can think of as a potential threat. That person with the tire iron who's 50 feet away, they don't present a threat. If they get close enough, they might have the opportunity now or the apparent intention to strike an officer with the tire iron, but they don't yet. So risk is something that officers can use tactics and communication to help address. The goal is to prevent risk from becoming threat, and really to prevent threat from becoming whatever that relevant harm is. But while threat can justify use of force, risk can't. An officer can't use force on someone who's holding a tire iron and 2 or 3 feet away while they're just changing a tire, because there's no apparent intention, there's no threat there. The officer can do something like back away, build distance so they aren't 2 or 3 feet away, or interpose the vehicle between themselves and the individual they're interacting with, or use communications. They could ask the individual to put the tire iron down, but they can't use force there because there's no threat.
I'm sorry to interrupt you.
This is what you get for having a law professor testify.
And they're trying so hard to take notes, and the court reporter's trying to take things down. So I'm going to slow you down a little bit, if I may, Professor.
Sure, sorry.
Oh, no problem. Then in assessing other potential risk factors, would you agree that the relative size of a person is a risk factor?
It's certainly a relevant consideration, yes.
But is it in and of itself a threat?
No, certainly not. Someone who's physically large may have a greater physical ability to inflict harm if they assault an officer, but that their size can't establish opportunity and can't establish intention.
And how about a recent drug use? Is that a threat or a risk?
Again, it's a relevant consideration, but it does not in and of itself establish a threat. It doesn't establish physical ability by itself to do anything. It doesn't establish opportunity to do anything, nor does it establish apparent intention. So it's certainly a relevant consideration in the totality of the circumstances, but officers can't use force on someone just because they're on drugs.
Now, I'd like to talk about, I'd like you to discuss the severity of the crime at issue. How is that relevant to the Graham analysis?
Sure. So as we're thinking about the concept of threat, the Graham factors really help us identify when there's a threat and how much of a threat. Severity of the crime can be best understood as a proxy for dangerousness. All other things being equal, an armed bank robber may be suspected to be more dangerous than someone who is cashing a worthless check, for example. So severity of the crime is really a proxy for evaluating how much risk someone might present, how dangerous are they.
And if we could go to the third factor then, the the active resistance, whether they are actively resisting arrest or attempting to evade arrest by flight. How is that relevant to your analysis?
So again, this is all part of that threat analysis, that second step in my framework. And this is getting at the behavior of the subject. So for example, someone who's attempting to evade arrest by flight is threatening the government's interest in apprehending that person. It's about identifying a threat of escape. Active resistance can be similar. It's a threat of someone frustrating the government's interest in taking them into custody, for example.
Are there different types of resistance?
Yes, absolutely.
What are the types, generally accepted definitions in policing as the different types of resistance?
Sure. So the concepts are certainly generally accepted, although some of the vocabulary differs from place to place. We might first identify someone who is compliant, who's doing what the officers want, no resistance at all, right? Then we might have someone who is passive or non-compliant. They're not doing what the officers want, but they're not doing anything against what the officers are telling them to do either. The classic example of passive resistance is someone who's just laying on the ground, refusing to get up when told. Then there's active resistance, which is typically defined as someone who is engaging their muscles in some way. Someone who's tensing up or someone who's running away is engaged in active resistance. The next level up, if we can say that, is active aggression. And this is where someone is not just engaging their muscles, they're engaging their muscles in a way that creates a threat of harm to the officers or someone else. And finally, the ultimate expression of active aggression is when a subject presents an imminent threat, again, as that term is defined, of death or serious bodily injury to officers or others.
If we could take that down, please. Now, I think we've gone through in a little more detail the first two steps of your four-step process. Talk about identifying facts that would have been apparent to a reasonable officer. We've discussed identifying threats. You also testify that you need to identify the foreseeable effects of the officer's actions. Can you explain what you mean by that?
Absolutely. What I mean by the foreseeable effects of the officer's actions is essentially, what is this use of force likely to do? Just as there's a spectrum of resistance, from no resistance to a whole lot of resistance, right, threatening the life of an officer, there's also a spectrum of effects that we might expect from an officer's use of force. So, for example, some uses of force are relatively minor and unlikely to cause any more than temporary discomfort. Other uses of force are substantially likely to cause death or serious bodily injury, what we would refer to as deadly force. As you're analyzing use of force, it's very important to focus on the foreseeable effects of what the use of force involved, and not the actual effects, not what actually happened. And I can give you an easy example. If an officer shoots at someone, that's a use of deadly force because it's foreseeable that discharging a firearm at someone is going to cause death or serious bodily injury. And that's true even if the officer misses entirely, or if the bullet hits the person but causes a very superficial injury. Let's say it just scrapes them. It's still a use of deadly force because of the foreseeable effects, not the actual effects. And that concept of foreseeable effect is what's foreseeable really at the time force is being used.
And Professor Soden, the fourth factor that you testified about, determining whether the officer's actions are appropriate, proportional, and reasonable. Can you please explain what you mean by appropriate, proportional, and reasonable?
Yes. So what we're talking about is sort of a balancing of harms here. This also pulls from Graham v. Connor and the Fourth Amendment standard, which talked about balancing the individual interest against the government interest. The idea is an officer cannot use more force than the situation justifies. That is, the foreseeable effects of the officer's use of force can't be disproportionate to the threat presented by the individual's actions.
And sir, did you take all of these factors into consideration in your performing your analysis in this case?
Absolutely, yes.
I ask if you assisted with the preparation of a demonstrative exhibit, demonstrative 953.
Yes, I did.
And would the use of that demonstrative exhibit assist you in explaining your analysis and testimony to the jury?
Yes, and especially how those factors apply.
Offer exhibit 953 for demonstrative purposes.
Any objection? 953 is received for demonstrative purposes only.
And before we publish that, first I'd like to publish what's been received as exhibit 17 and ask you, sir, if you identified in accordance with your process what particular force you evaluated. So if you'd publish exhibit 17.
Yeah, so there are two components to the use of force here. The first is the defendant's knee or shin over Mr. Floyd's neck. The second is Mr. Floyd in that prone position while restrained, what I may refer to as prone restraint.
At this time, I'd like to publish exhibit 953. One moment, Your Honor. Did you also look at a demonstrative exhibit, exhibit 949, that showed the relative position of the defendant and the other officers on Mr. Floyd?
Yes, I did.
All right.
And again, here you can see the two components of the use of force, the knee across Mr. Floyd's neck, as well as him being in the prone or face down position while restrained.
Offering exhibit 949 for demonstrative purposes.
949 is received for demonstrative purposes only.
And using what you saw as exhibit 17, which has been received substantively in 949, again, explain what particular force you are analyzing and over what period of time.
Yeah, so again, both the prior image, the photograph, and this this demonstrative show the knee, the defendant's knee across the back of Mr. Floyd's neck and Mr. Floyd face down in that prone position while handcuffed. The use of force here, use of force is not always a flash in the pan event. Firing a bullet might be, but other uses of force, including the uses of force in this case, are sustained. So they start when Mr. Floyd is put into the prone position and when the knee goes across the neck, and the uses of force continue until the knee comes off the neck and Mr. Floyd is taken out of that prone position.
And you indicated that the use of force included the defendant's placement of the knee on the neck. The other knee, where did that appear to be placed?
Yes, variously on Mr. Floyd's upper arm, shoulder, or upper back.
Okay.
I would put that for purposes I imagine we will discuss as part of holding Mr. Floyd in the prone position while restrained.
What was your determination of the duration of this restraint period?
From the time Mr. Floyd was initially placed in the prone position, 9 minutes and approximately 29 seconds until the knee was taken off of his neck and he was taken out of that prone position. And
did you determine this period of time based on your review of using Officer King's body-worn camera footage starting at 20:19:14 and ending at 20:28:43?
Yes, that's correct.
And is it your testimony that, according to national standards, the use of force must be reasonable when it starts, and it must continue to be reasonable during the entire duration?
Sustained. Rephrase.
And sir, can you make any comment about how long the particular use of force must be reasonable as in the defined restraint period?
Yeah, so a use of force that is sustained over a period of time does have to be reasonable at the time force is initiated. That is when force is first used and throughout the duration that that force is being used.
And I believe you testified that using and applying these national and constitutional standards is viewed through the eyes of what a reasonable police officer at the scene. Is that correct?
That's correct. That's part of the Graham v. Connor framework, as well as certainly has been adopted into generally accepted police practices.
So then, using your four-step analysis to identify relevant facts and circumstances that would have been apparent to a reasonable officer on the scene, would you please summarize for the jury, based on your review, what information would have been available to a reasonable police officer in the defendant's position prior to his arrival at the scene that day?
Yes. So the reasonable officer on the scene standard is an objective one. We don't just adopt an officer's idiosyncratic subjective perspective. We take the reasonable officer and put them into the actual officer's position and say, what would the reasonable officer have perceived, seen, heard, or believed? In this case, prior to the reasonable officer in the defendant's position arriving on scene, he would have been aware that there was a call, I believe, dispatched about counterfeiting, that the individual was described as possibly intoxicated. The individual later identified as Mr. Floyd was identified as possibly intoxicated, that two other officers had taken the call, had, I believe, taken someone into custody and called Code 4, identified that they had the scene under control and did not need additional resources.
Now, what I'd like to do is turning to the demonstrative 953. Right? You can see the beginning of this use of force evaluation, and you have this divided into different sections. Up top, you have threat factors. At the bottom, you have foreseeable effects of force. You have the defendant and his conduct up top, activity of Mr. Floyd on the bottom. Is that right?
Yes, the threat factors are really the behaviors of Mr. Floyd and whether they presented any threat. And the foreseeable effects of force are really about the effects of the use of force on Mr. Floyd. Yes.
Now, what I'd like to do at this time is show you a first clip. This is taken from what has been received into evidence as Exhibit 45, beginning at timestamp 2017:40. And you see on the demonstrative here, it says defendant arrives on the scene. I'd like to publish that clip first.
Just the chair.
You can't win, bro. You can't win. I'm not trying to win. Go on, get in the car then. I'll be ground, anything. Go get in the car. He know it. He know it too, Mr. Officer. Y'all hear me? Don't do me like that, man. Please. Okay, can I talk to you, please? So you get in the car. We can talk. I am claustrophobic. I'm hearing you, but you're not working with me. God, I'm claustrophobic. Get in the car, man. Get in the car. Get in the front. Please. No, you're not in the car. I'm claustrophobic, Mr. Officer. Get in the car. Okay. I'm not a bad guy, man. Get in the car. I'm not a bad guy. You ain't gonna win.
All right. Now, sir, this is taken from the perspective of the defendant's body-worn camera. Is that right?
Yes, it is.
What information would have been apparent to a reasonable officer based on the exchange we just observed?
So a reasonable officer in the defendant's position would have realized that Mr. Floyd was in handcuffs, would have realized that there were two MPD officers already on scene, along with two more now, the defendant and the officer that he arrived with, would have realized that there was what we might call a point of conflict between the officers and Mr. Floyd, who did not want to get into the back of the car. One of the things that signifies is generally that, generally that the individual has been searched. Typically, an officer is not going to load someone into a squad into the back of a car until after they've been searched. As I said, a reasonable officer would have seen that this appears to be a point of conflict, would have heard that Mr. Floyd was describing himself as claustrophobic, would have understood Mr. Floyd to be offering some alternatives, right? Laying on the ground or sitting up in the front of the car, as opposed to being put in the back of the car. In other words, the point of contention does not appear to be police custody, right? Mr. Floyd does not appear to be objecting to being kept in police custody, but instead to be objecting to being put in the back of a vehicle.
Now, you're aware that the officers attempted to place him in the back of the vehicle, and he was eventually taken back out of the back of the vehicle and into the street. Is that right?
Yes, there was some non-compliance initially, and then what we would describe as that active resistance, what appears to be physical engagement of the muscles in a non-assaultive or non-aggressive way, leading ultimately to officers' decision to take him out of the rear passenger side of the vehicle.
And so, in your view, a reasonable officer would not have perceived this as active resistance, as an act of violence or active aggression, I should say.
That's correct. This does not appear to be active aggression in the sense that Mr. Floyd does not appear to have the intention to assault or attack the officers here. His efforts appeared aimed at not being in the backseat of the car.
Now, I'd like to publish the second clip, clip 2, which is taken from Exhibit 43, which is Officer King's body-worn camera. And the footage begins at timestamp 20:19:01, and it's labeled Floyd placed prone. If you'd please publish that.
For what? Please, man. I can't fucking breathe. Here, come on out. Look at you. Thank you. Thank you. Get up off the ground.
Pause. All right. So we're paused here at mark 20:19:08. Is that right?
Yes.
Now, at this point, can you please describe what would have been apparent to a reasonable officer at the scene?
So, as you heard, Mr. Floyd has already said, I can't breathe. And as officers pull him out of the backseat of the car, again, that point of contention from earlier, you hear Mr. Floyd say, thank you.
And he is also appears to be handcuffed. Is that right?
He is handcuffed, and I believe, although not entirely clear from this freeze frame, I believe the video will show that he's on his knees at this point.
If you'd resume playing clip, please.
Yeah, on the ground. On the ground. Ah, my knees. Right. You got your restraint. Hobble. Okay. I'll grab that.
All right. Now, from that segment that we just watched, clip 2, can you please describe what information would have been available to a reasonable officer in the defendant's position at that time?
Yes. So again, focusing on the threat analysis here in this step, Mr. Floyd remains handcuffed. He's put from his position on his knees, where he's said, thank you, and I appreciate that, having been taken out of the backseat of the car. He's originally pushed over onto his left side, sort of facing the car, and then rolled from his left side into the prone position, into that face down position.
Now, prior to having him, I guess, first brought down to the ground, at the time he was placed on his knees, I believe you indicated that he said, I appreciate that, or thank you, something to that effect.
Yes.
All right. At that point, was it necessary for the officers to prone him?
No.
Why not? Why not?
Again, looking at the threat analysis here, it's clear from the number of officers and Mr. Floyd's position, the fact that he's handcuffed and has been searched, he doesn't present a threat of harm. His actions don't indicate that he presents any threat of escape. And as he's saying thank you for being taken out of the backseat of the car, it would certainly suggest that the point of conflict that had provoked his resistance in the first place is over. It suggests a lack of intention. Given the range of other alternatives available to the officers, it's just not appropriate to prone someone who is at that point cooperative.
What is the purpose of placing someone in the prone position in accordance with generally accepted police standards?
Yes, the The prone position is a very useful position in policing for getting control of someone for purposes of handcuffing them. Again, the prone position is just basically face down, right? Their chest, front of the hips on the ground. When officers are struggling with someone, or when they're handcuffing someone who they anticipate struggling with, you'll often see officers put someone into that prone position for purposes of handcuffing, because it's very difficult for someone to fight or to resist as they're face down on the ground, especially once their arms are out at their sides. However, the prone position, as useful as it is for handcuffing, is supposed to be transitory. It's used for handcuffing, and then as soon as someone has been handcuffed, you take them out of that position for, I imagine, reasons that we'll discuss.
And the position that you take them out of and put them into, is that the side recovery position?
It is, yes.
If you could then, I'm just recalling the clip we saw initially when Mr. Floyd was on his knees and he was brought to the ground, what position was he in initially?
So initially, as he's on his knees, when he's brought over onto his left side, that would be consistent with the recovery position, laying on his side with his legs either straight or bent.
And then from that, essentially what would be the side recovery position, he was actually brought into the prone position from the recovery position. Is that right?
Yes, that's correct.
Right. And at this point, or shortly after this point, the prone position, the prone restraint position begins. Is that right?
Yes, when he is put into that prone position, that's where I would say that the prone restraint begins. He is restrained and prone.
Now,
as well as the knee across the neck. These are really the two uses of force that I'm focusing on.
all right. And this is where you've indicated as the beginning of the restraint period. Is that right?
That's correct. That red line indicates where the prone restraint and the knee across the neck begins in that timeline.
Now, I need to ask you, at the time that he was placed prone, when this use of force was done, was Mr. Floyd a threat?
So again, threat is specific, but I don't see him presenting a threat of anything. He was not a threat of harm to the officers, even to the extent he had physical ability. He didn't have much in the way of opportunity to assault or harm the officers. And just as importantly, there's no specific and articulable facts that an officer, a reasonable officer in the defendant's position, could use to conclude that he had the intention of causing physical harm to the officers or others. It's very clear that although he had legs, so I suppose he had the physical ability to run away, he does not have the opportunity to do so. And again, there's no facts from which we could assess any intention to escape, so no threat of escape. And really, in light of the situation, there's not even a credible threat of obstructing the investigation. With 4 officers in the immediate area and one more, I believe a park police officer, maybe half a block away across the street, there are ample resources on scene to maintain control and custody of Mr. Floyd. 2 officers can stand with him, and the other 2 can go about doing the what was ultimately a forgery investigation.
And if we could go to the next clip, please. Right, and that clip is taken from what's been received as Exhibit 49, which is the body-worn camera of Officer Tao. Is that right?
Yes, it is.
And it starts at 20:21:31. If we could publish that, please.
I can't breathe, man. Please. Please let me stand. No. Please, man, I can't breathe.
Can you please explain to the jury what you heard and saw in this clip that's relevant to your analysis?
Yes, so there are a couple of things. First, of course, you hear Mr. Floyd saying that he can't breathe. That will come up as we talk about the foreseeable effects of the use of force. You'll also hear the officers discussing and ultimately concluding that they aren't going to use the hobble restraint.
Did they discuss why they wouldn't use the hobble restraint?
You hear, yes, you hear one of the officers say, because something like, if we use the hobble, a sergeant's going to have to come.
Now, can you please tell the jury what generally how a hobble restraint system works and what it's for?
Yes, a hobble is used to limit the motion of someone's legs. So if they're kicking or flailing around with the legs, especially someone who's in, for example, the backseat of a police car who may be kicking out the windows or something like that. And essentially the hobble goes around the ankles and binds the ankles together, and then is connected to a belt piece, sort of a component around the midsection to slightly bend the individual's legs. Historically, the legs used to be bent up behind someone. Think of laying on your stomach and then kicking your feet up towards your butt. The way hobbles are generally used now is the feet aren't behind the individual, they're just brought up. So the knees are kept in front of the body and brought up a little bit. Again, the point is just to make it much more difficult, if not impossible, for the individual to kick.
And what would a reasonable police officer on the scene use to determine whether a hobble restraint is appropriate?
So hobbles are generally appropriate when officers cannot effectively restrain someone using only handcuffs. When they have someone who is continuing to kick or flail or flop around uncontrollably.
Is the absence or presence or the need to summon a supervisor an appropriate reason to either use or not use a hobble?
No, if the situation justifies a hobble, then officers should use the hobble, regardless of the fact that that means a supervisor will have to respond. If the situation does not justify a hobble, then they shouldn't use a hobble, regardless of the requirement to summon a supervisor.
And would you agree that a hobble is just sort of a brand name for a form of MRT or maximal restraint technique?
Yeah, so hobble, 4-point restraint, maximal restraint. There are specific brands like the RIP hobble, but yeah, these are all essentially the same concept that we're talking about.
And was the application of force by the officers without the hobble essentially a maximal restraint technique, but without the use of that tool?
To the extent that the hobble will effectively immobilize someone and keep them from kicking, then what you see here is officers controlling Mr. Floyd's upper body, middle body, and lower body, which would keep him from kicking. So although not a perfect parallel, I would certainly describe it as a behavioral analog of a maximal restraint or a hobble-like technique.
And when an individual is placed in a maximal restraint, the hobble, are they supposed to be placed in the side recovery position?
Absolutely. Just like handcuffing, as soon as an individual is restrained, handcuffs or hobble, get the person off of their stomach, out of the prone restraint and into a side recovery position.
And I'd like to then move to the next segment.
If I may,
We can move to the next segment here. We're looking at the next clip, which is Exhibit 47, beginning at 20:23:47. If you would publish that, please.
Roll on the side.
All right. Can you please, and you can move forward then the next. Please explain to the jury what you heard that was relevant to your analysis in that exchange.
So there's one officer who's suggesting or asking about whether they should roll Mr. Floyd onto his side, and you hear the defendant say, no, he's staying put, and they're going to keep him in the prone restraint.
Okay. And what was the significance of that?
It would indicate to a reasonable officer that at least one person there did not feel that Mr. Floyd presented the level of threat that required them to keep him in that prone restraint position, that at least one person was suggesting we can flip him onto his side, or should we flip him onto his side?
Okay. And if you could proceed to the next clip. And again, if you could play that segment, Exhibit 47 at 20:25:38. Move forward. And again, we heard a similar exchange. Is that right?
Yes, we did, along with one of the bystanders in the background saying he's not responsive right now. Both of those are factors to consider in identifying the threat that Mr. Floyd presented. If he's not responsive, obviously he can't present any threat. And the fact that you have an officer suggesting roll him onto his side, again, suggests the perception that officers are fully capable of maintaining custody and control of Mr. Floyd without keeping him in that prone restraint position.
Now, in accordance with your 4-step process, the next step is to identify foreseeable effects of the officer's actions. Is that right?
Yes, that's correct.
You did that in this case. Is that right?
Yes.
And I'd like you to please discuss, if you could advance the slide here. Okay. Right, go ahead. We have some potential foreseeable effects. What does a reasonable officer have to take into account when determining what the potential foreseeable effects of their actions are?
Sure. So under that first step of the analysis, we look at the facts and circumstances as they would have been aware to a reasonable officer on the scene. And some of those facts and circumstances may indicate that there are specific foreseeable effects of force. So in this case, again, we have those two separate components of force that I'm going to address. One is the knee across the neck. That foreseeably can cause pretty significant serious bodily injury or death. If you think of someone who's laying face down, where the head or face is against the ground and the chest is against the ground, that means the neck is kind of like a suspension bridge, right? So it's generally accepted in policing that you do not put weight down on someone's neck in that position because of the potential that the neck won't be able to handle that weight. And you can end up damaging the structures of the neck. That's kind of generic. There's nothing specific that we need in this case. That applies to all defendants. So I apologize, all individuals. There are also foreseeable effects of keeping someone in that prone position. Prominently, what's called positional asphyxia, someone who starts having trouble breathing, who can't take in over time the amount of oxygen that they need to sustain their life functions. This is something that's been very well known in policing for at least going on 30 years. The prone restraint position limits the ability of someone to breathe. And there are some additional specific factors relevant to this case that increase the susceptibility of Mr. Floyd to positional asphyxia, and that a reasonable officer would have known prior to the use of force. Specifically,
ask another question.
And those additional risk factors, would those include the downward pressure of the weight of
Overruled.
the officers?
Yes, absolutely. Additional weight on a subject's back can further compromise their breathing, rendering them more susceptible to positional asphyxia. Apologies, Your Honor.
All right, at this time, I'm going to ask that the next clip 6, which is taken from Exhibit 49, which is, I believe, Tao's body-worn camera, and it starts at timestamp 20:21:50. You would play that, please.
What do you want? I can't breathe. Please, the knee in my lips. I can't breathe shit.
Well, get up, get in the car, man.
I will.
Get up, get in the car.
I can't move.
I just wiped the whole.
Ah!
Get up, get in the car.
Mama,
Get up.
Mama, I can't.
Y'all opportunity to get in, bro.
All right.
You can't win.
My knee,
You
my
can't
neck.
win, man.
And can you please explain, Are we looking at a break? Were you signaling to me, Judge, that we?
I don't know. For the next 10 minutes when a good break is.
Oh, okay. Thank you, Your Honor. With respect to this portion that we just viewed, what did you see that was relevant to your analysis with respect to the potential foreseeable consequences of the officer's actions?
So two things really stand out. One is you hear Mr. Floyd saying that he can't breathe. And one of the indicators of susceptibility to positional asphyxia is that someone starts having difficulty breathing. The other component, one of the factors that can increase the susceptibility to positional asphyxia is drug or alcohol intoxication. Even before the defendant arrived on scene, the counterfeiting suspect, who was later identified as Mr. Floyd, was described as possibly intoxicated. And here in this clip, you can hear the officers discussing the likelihood that he's intoxicated, that he was found with drug paraphernalia on him, and that they suspect there might be other drugs in play.
And there are other things that an officer can listen to, even including a report of distress from the person themselves. Is that right? Person upon whom force is being applied.
Absolutely. If someone is describing that they are experiencing medical distress, then officers have to take that into account as they're evaluating the continued effects of keeping someone in this case, a prone restraint position.
I'd like to play clip 7, which is taken from Exhibit 43, King's body-worn camera at 20/22/18. We publish.
I'm through. I'm through. I'm claustrophobic. My stomach hurts. My neck hurts. Everything hurts. There's water or something. Please. Please. I can't breathe.
Hey, stop talking, a lot of
They
yelling.
will kill me. They will kill me, man.
Takes a heck of a lot of oxygen to
Come on, man.
Now, during what we just viewed as clip 7, was the defendant, was the use of force the same as when you began analyzing this at point 0?
Yes, the officers are maintaining Mr. Floyd in that prone restraint position, but there are some additional indicators that the foreseeable effects of force are occurring, that he's experiencing positional asphyxia.
And did you hear Mr. Floyd say plainly that he was experiencing some form of medical distress?
Not only does he indicate it with the words he's using, saying that he can't breathe, but even compared to that prior clip, his voice is slower and thicker. So both what he is saying and how he is saying it would indicate an increased medical distress.
And would a reasonable officer on the scene then, hearing this, have at least been aware of the complaint?
Absolutely, especially when you hear an officer responded to that complaint, certainly an indication that an officer was aware of it.
Okay. And you reviewed these body-worn cameras on numerous occasions, is that right?
Yes, many times.
Did you have an opportunity to review body-worn camera in which the defendant's voice could be heard at the same time that you could see him as the speaker?
I believe there is, yes, he is identifiable as the speaker. I forget which body-worn camera that is, or maybe it's the comparison of multiple body-worn cameras, but he is identifiable as the speaker there.
And I'm sorry, and in the exchange we just heard, was he identifiable as the speaker who was saying,
Yes.
If we could go to clip 8, just taken from Exhibit 47 at 20/24/40.
I think he's passing out.
And if you could advance, can you please explain to the jury what you heard and saw in that clip that's relevant to your analysis as to the foreseeable effects of force?
So the first thing you hear is one of the bystanders say he's passed out or something like that, and that's echoed by one of the officers who says he's passing out. As we're assessing, first, as we're assessing threat, if we can jump back to that for a second, someone who's passing out obviously does not present a threat. You don't hear Mr. Floyd, which is notable because until he stopped speaking, his vocalizations were kind of incessant, right? There weren't very many periods where he wasn't speaking until he wasn't. And you hear I'm sorry, back to the officer, you hear an officer saying he's passing out. That again indicates an increasing level now of medical distress.
And the officer who was stating this was in close proximity to the defendant at the time he was saying it. Is that right?
He was. I believe this is Officer Lane, who is at Mr. Floyd's feet. So maybe of the officers who are on Mr. Floyd, may be in the worst position to identify exactly what Mr. Floyd is going through, but still identifying that he's passing out.
In the clip that we just viewed at 2024-40, that was approximately 40 seconds after a time that you've identified that Mr. Floyd had said, "I can't breathe," approximately 27 times. Is that the incessant speech you were talking about?
Yes. Before he fell silent, Mr. Floyd said, "I can't breathe," by my count, at least 27 times.
Now, if we can advance to the next clip. And I guess before we publish the next clip, which was from Exhibit 43 at 2025-40, you made a notation here on the demonstrative exhibit regarding Mr. Floyd's movement and his speech. Is that right?
Yes, that's correct. So from approximately 4 minutes and 45 seconds after the prone restraint had begun, for the next 53 seconds, Mr. Floyd is silent. He's not saying anything, but he's still moving slightly.
And would this have been readily apparent to a reasonable officer at the defendant's vantage point at that particular moment?
Absolutely.
If we could publish the next clip.
Right now, he's not responsive right now, bro. No, bro, look at him. He's not responsive right now, bro. Bro, are you serious? He's gonna just have to deal with that on his head, bro? Is he breathing right now? Check his pulse. Check his pulse. Check his pulse, Kyle. Kyle, check his pulse. Kyle, check his pulse, bro. Bro, check his pulse, bro. You broke me, bro. You broke me. What is that? What do you think that is? You call when he's doing okay? You call when he's doing okay?
And what did you see in that clip that was relevant to your foreseeable effective force analysis?
So here the audio starts with the bystanders saying that Mr. Floyd is not responsive, pleading with officers to check his pulse. Officer King does so, spends 6 or 7 seconds checking, looks like 2 locations, or maybe trying to get a pulse on the same location twice, before ultimately announcing that he can't find a pulse. At that point, the defendant says, "Huh," and Officer King clarifies and says, I was trying to find a pulse," or something like that.
Jumping up to the threat factors then, because we're looking at the same event, is Mr. Floyd presenting anybody a threat at this point?
No, someone who does not have a pulse does not present a threat in any way.
Now I'd like to advance to clip 11. Right, if you would publish that, please.
Not responsive right now. You guys might want to.
Right now.
And please tell the jury what you saw relevant to your analysis with respect to foreseeable effects.
So you hear Officer Lane describe Mr. Floyd as not responsive. This is as the paramedics are arriving, and Officer Lane is directing them by saying that Mr. Floyd is not responsive. Again, back up to the threat factors, certainly cannot be a threat if he's not responsive. And now even more indication that the use of force is having deleterious effects on Mr. Floyd's health.
And if we can advance to the next clip. Right. point, and I don't believe that's oh yes, actually go ahead and publish that. It's the Fraser video 202842 exhibit 15.
The fact that you guys aren't checking his pulse and doing
What is it you see here that was relevant to your analysis?
This is immediately before Mr. Floyd is loaded onto the stretcher, and you see the defendant take his knee off of Mr. Floyd, and shortly after that particular clip, Mr. Floyd is rolled and lifted onto the stretcher.
And so would that then mark the end of the restraint period at 9 minutes and 29 seconds?
Yes, it would.
Your Honor, this would be an opportune time for a break.
The jury, let's take our 20-minute break.
a reminder, you're still under oath.
Yes, Your Honor.
Mr. Swisher.
Thank you, Your Honor. Sir, during this restraint period that you've defined from second 0 to 9:29, did George Floyd present a threat of escape during this encounter?
No, he did not.
Did he present a threat to physical property?
No, he did not.
Did he present a threat to the physical safety of the officers
No, he did not.
or anyone else?
No,
Did he present any sort of threat at all?
no.
Your analysis, you noticed there were a number of bystanders in the area. Is that right?
Yes, that's correct.
Did your analysis include an assessment of what impact bystanders may have had on the situation?
Yes. So now moving into the fourth step of my analytical framework, the facts and circumstances include the bystanders and their interactions.
All right. And at this time, I'd like to play clip 12, which is Exhibit 49, starting at marker timestamp 20:22:22.
Just move it. My stomach hurts. My neck hurts. Everything hurts. Get some water or something. Please. Please. I can't breathe. They gonna kill me. They gonna kill me, man.
Bro, with your feet on their neck, man. You get off the
Come on, man.
How many bystanders did you observe at that particular moment in time?
A handful. There are 5 visible on the screen. At one point, it looks like someone a little further to the left of the screen is maybe walking across the street.
And this is another example of a clip that we've previously seen. Is that right? Just taken from the body-worn camera of Officer Tao, who had was oriented toward the bystanders. Is that right?
Yes. So the video clip that's sort of directly below the 2022-18 clip, we heard Mr. Floyd saying the same things. That was when I was describing his voice getting slower and thicker. In the end of that clip, and at near the end of this clip that we just watched, you can hear one of the bystanders make a statement about the officers being on Mr. Floyd's neck. That is the first time in this interaction, more than 3.5 minutes since the use of force began, that any bystanders are criticizing what the officers are doing. The only prior comments from one of the bystanders are encouraging Mr. Floyd to comply with the officers.
Right. And so prior to this point, just describing the noise level or the volume of the bystanders and their voices at the time that George Floyd is expressing some medical distress to the defendant.
As you can hear, the bystanders are pretty quiet. You hear Mr. McMillan's, I believe it is, voice near the end of the clip. But other than that, it doesn't sound like anything more than normal road traffic.
If you could please then advance to clip 13. And this is from Exhibit 15, which is the Frazier bystander video at 20:23:11. If you would publish that, please.
They're being held down. They'll kill me. I can't breathe.
This is why you don't do drugs, kids.
I can't breathe.
What did you hear in that clip that was relevant to your analysis of other facts and circumstances as related to the bystanders?
So you hear Officer Tao say something like, "This is why you don't do drugs, kids," to the crowd. You can see when he makes that comment, he's standing sort of parallel or maybe next to the officers. That's relevant because if you are concerned about a crowd, if you are worried about interference from bystanders, you don't say things that are likely to exacerbate that situation with the crowd. And a comment like, "This is why you don't do drugs, kids," is not report building. It is.
I'm gonna, excuse me. I'm going to sustain as cumulative.
At some point, did the noise level of the crowd increase?
Yes, it did later in the incident.
And at this point, I'd like to play clip 14, which is from Exhibit 15 at 20:29:03. You can see before we play it from the timeline, this occurs after the ambulance had arrived and the restraint period was over. Is that right?
That's correct. At this point, the use of force was concluded, and Mr. Floyd was, I believe, on the gurney or being loaded into it.
All right. If you would publish that last clip, please.
Don't touch me. Do not touch me again. Don't touch me. Don't touch me. Don't touch me. I've been here the whole time. Don't touch me.
And if you can take that down. And again, that happened after the restraint period was over. Is that right? And the paramedics had arrived?
Yes, it did. And as we discussed, as you're evaluating use of force, you look at the facts and circumstances as they existed at the time, which means you can't consider events that occurred later after the use of force is concluded to justify earlier use of force.
In your analysis, did the bystanders present a threat during the restraint period?
No, they did not present a threat to the officers.
And it's judged by a reasonable officer on the scene in the defendant's position. Would a reasonable officer have perceived them as a threat?
No, the facts and circumstances suggest not. For example, Officer Tao did not interpose himself between the bystanders and the other officers until more than 6 minutes into the prone restraint period. His communications with the crowd were, as discussed, when individual bystanders stepped into the street and were directed back up onto the curb. With one exception, they did so within a few seconds without any type of physical contact. When there was physical contact between Officer Tao and one of the bystanders who looked like an older child or a young boy, that bystander was swiftly grabbed and pulled away by another one of the bystanders.
Now, did you see the defendant interact with or in the area of any of the bystanders after the restraint period was over?
After the restraint period was over, yes, the defendant left the position where he had been during the restraint and walked back, I believe, to the squad, the police vehicle, walking by several of the bystanders, not really interacting with them, but just walking by them or near them. And then once in his vehicle, he interacted with, I believe, the same bystander we had discussed earlier, Charles McMillan, apologies.
And do you recall, in reviewing this matter, reviewing a statement that the defendant made to Charles McMillan explaining his use of force upon Mr. Floyd to Mr. McMillan?
Yes, I do.
Do you recall what the defendant's explanation for his force level was?
So this, of course, will not be an exact quotation, but it was something akin to describing Mr. Floyd as a pretty big guy, possibly under the influence or on drugs, and that officers needed to keep control over him.
Okay. And what is your assessment of this explanation? Does it justify the level of force based on the defendant's explanation to Mr. McMillan that was used on Mr. Floyd that day?
All of those individual statements are true. Mr. Floyd was a large individual, and there was, as we've discussed, ample reason to suggest to a reasonable officer that he may be impaired by alcohol or drugs. But no, officers in this situation, and a reasonable officer would have perceived in this situation, that they could maintain control of him without putting a knee on his neck or keeping him in that prone position.
Is there a national recognized standard for police officers with respect to the duty to render aid and preserve life?
Yes, it has long and rather loudly been said that the sanctity of human life is the highest priority in policing. That's absolutely generally accepted in policing.
And what does that include? What does that mean in practice?
It has a couple of different implications, one of which regard to the use of force itself, the second of which is the duty to assist or render aid to the extent that the officer has the ability and equipment to do so when individuals are in medical distress.
What if the officer doesn't believe the person who's reporting to be in medical distress?
Officers are not paramedics, they're not EMTs, they're not medical diagnosticians, they're not doctors. The person may be lying, but officers have a duty to respond to the situation as it appears. They cannot take for granted, just because some people lie to the police about medical distress, that everyone they are interacting with, or that any one in particular person they're interacting with, is lying about being in medical distress. You have to take that seriously.
And what facts and circumstances does a reasonable officer take into account when determining whether or not they should render medical aid?
A whole range of factors, what someone is saying, how they are saying it, observations by other people. In this case, in the clips, you hear bystanders identifying that Mr. Floyd is not responsive, for example, or may not be breathing. So whether the reasonable officer is really paying close attention to Mr. Floyd, or whether the reasonable officer is really paying closer attention to the crowd, the point is the same. The evidence is suggesting that there is medical distress here. Of course, you also look at the individual's behavior. So in this case, you can not only hear Mr. Floyd saying that he can't breathe, but you hear the change in his voice, as we discussed. You hear him stop talking. You see him stop moving. And the reasonable officer here would have been aware that at one point he no longer had a pulse. All of those individually are indicators of medical distress. And as you look at them comprehensively in order, it's signs of increasing medical distress.
Then, Professor, I'd like to go to the last stage of your four-part analysis, and that is to determine whether officers' actions are appropriate, proportional, and reasonable. And I'd like you to now please share with the jury what conclusions that you have reached regarding the use of force by the defendant on Mr. Floyd. So I'd ask you first, you have an opinion to a reasonable degree of professional certainty as to whether the type of force used by the defendant on George Floyd on May 25, 2020 constituted deadly force.
I do, yes.
And what is that opinion?
That it did. The use of force had the foreseeable effect and a substantial likelihood of resulting in death or great bodily harm.
Do you have an opinion to a reasonable degree of professional certainty as to whether the type of force used by the defendant on George Floyd on May 25, 2020 was reasonable as viewed by a reasonable police officer on the scene?
I do have such an opinion, yes.
What is that opinion?
Both the knee across Mr. Floyd's neck and the prone restraint were unreasonable, excessive, and contrary to generally accepted police practices.
When, in your opinion, did the unreasonable force begin?
When Mr. Floyd was initially put into the prone restraint position and when the defendant's knee was placed onto his neck.
And when did it end?
When the defendant's knee was lifted off of Mr. Floyd and he was taken out of the prone restraint position.
Do you have an opinion to a degree of reasonable professional certainty as to whether defendant's use of force, whereby he restrained Mr. Floyd in that prone position for 9 minutes and 29 seconds on May 25, 2020, was reasonable as viewed by a reasonable police officer on the scene?
Yes.
And what is that opinion?
No reasonable officer would have believed that that was an appropriate, acceptable, or reasonable use of force.
And was the force, was the force unreasonable as it started and as it ended?
From the time it was initiated and throughout its duration, yes.
And finally, do you have an opinion to a degree of reasonable professional certainty as to whether the defendant appropriately rendered medical aid to Mr. George Floyd on May 25, 2020 in accordance with generally accepted police practices?
I do, yes.
And what is that opinion?
The failure to render aid to Mr. Floyd, both by taking him out of the prone position and by rendering aid as his increasing medical distress became obvious, was unreasonable and contrary to generally accepted police practices.
Thank you very much, Professor Stoughton. I have no further questions, Your Honor.
Mr. Nelson.
I may have just a moment, Your Honor. Good afternoon, sir. Thank you for being here. Mr. Stoughton, correct?
Stoughton, yes, but
Okay.
nobody gets it right, so I won't take it personally.
All right. So, Mr. Stoughton, you testified that you were a police officer for approximately 5 years before going into the more academic nature of your work.
I was full-time with the police department for a little less than 5 years and stayed on as a reservist for another 6 months, and was an investigator before ultimately going to law school and taking an academic route, yes.
Okay. And you analyzed this case principally from an academic standpoint, correct?
I would not describe it as academic. No, I would describe it as the professional standards for policing.
Okay. And the Graham versus Connor standard that you've discussed, I mean, there's more to it than just those three factors. Agreed?
The Graham v. Connor standard is the Fourth Amendment standard. Yes, there's more to Graham v. Connor, and there's more to the professional standard than just Graham v. Connor.
And that would include that the analysis of an officer's use of force is viewed from the totality of the circumstances, correct?
As viewed through the lens of a reasonable officer, yes.
So it's not just 14 10-second clips. It's the totality of the circumstances viewed through that lens. Agreed?
Yes.
And in fact, one of the standards that Graham versus Connor establishes is that shouldn't be viewed from the 2020 lens of hindsight, right?
The 2020 lens of hindsight is an admonition to not rely on evidence that was not available to officers at the time. It's part of the reasonable officer on the scene standard. It, of course, doesn't mean that we can't evaluate an officer's use of force after the fact.
Understood. But the information, what we look at is the information that was available to the officer on scene at the time based on the reasonable officer standard, right?
Not exactly. It's the information that was available to a reasonable officer at the time, not the information that the individual officer had.
Understood. So we look at it from a broader lens than just the officer that was actually on scene. Agreed?
An objective lens, yes.
Right. And that includes all of the things that would be known to a reasonable police officer on the scene.
Yes.
All right. So you described your kind of four-prong approach to the analysis of this particular case. Same approach you take in every review you've done, correct?
Yes.
And ultimately, you focused the majority of, as I understood, the majority of your testimony, your direct testimony, on the third and fourth prongs of that analysis. Would you agree with that?
No, I would describe most of my testimony as being about the second and third prongs, whether Mr. Floyd presented any threat, and if so, how much, and the risk factors to Mr. Floyd, the foreseeable effects of force.
Okay. I apologize. You're right, the second and third. The fourth being the generally accepted police practices, right?
Yes.
All right. So let's start kind of from the beginning. One of the things that a reasonable police officer is entitled to do is rely on his or her training. Agreed?
In part, an officer is not entitled under that professional standard to rely on training that's unreasonable. So the training has to be consistent with generally accepted police practices.
But if the training is based upon generally accepted police practices, a reasonable officer is entitled to rely on his or her training. Agreed?
I'm not entirely sure what you mean by entitled to. I'm analyzing whether an officer's actions are consistent with those generally accepted police practices. So if the training is consistent and the officer's behavior is consistent, then yes, but I'm not quite sure what you mean by entitled.
When an officer approaches any use of force or any arrest, one of the things that a reasonable police officer takes into consideration is his or her training. And provided that that training is based upon generally accepted police practices, they can rely on their training in assessing the risk, the threat, all of the things that you've discussed. Agreed?
I think you're asking two different questions. So one question is, what does an officer rely on? And the second is, how does that factor into the analysis of an officer's actions? And those are very different questions.
Okay. So let's answer them one by one.
Sure.
Starting with the first. How would you answer the first?
Yes, officers generally rely on their training. At least I certainly hope that's the case.
And that also factors into the analysis, correct?
No, I'm not assessing an officer and whether they satisfied their training standards. I'm looking at whether they satisfied generally accepted police practices. So from my purposes, it's irrelevant whether an officer is doing what they were trained to do or what they were not trained to do, because I'm looking at the professional norms that we expect.
Fair enough. Okay. Now, when an officer, let's kind of look at those second and third prongs step by step a little bit again. You testified that when an officer, a reasonable officer, is allowed to take into consideration what information they would have received before the use of force began. Agreed?
Yes.
And in this particular case, you understand that Officer Chauvin was initially dispatched to this offense, correct?
Yes.
That dispatch was subsequently canceled, correct?
Yes.
That a second set of officers responded or took over the call, so to speak, correct?
Yes.
And that Officer Chauvin, without the other officers on scene, was dispatched in an emergent state. Agreed?
I explained the last part, I'm sorry.
The officers on the scene did not request backup. A dispatcher made the determination that these officers needed assistance, correct?
Well, offhand, I don't remember exactly the justification for the response, but I will accept that if that's your representation.
And ultimately, so if an officer is canceled from a call, but then in an emergent situation, that's going to give a reasonable police officer a heightened sense of awareness as they respond to that call. Agreed?
It depends on what information is provided to the officer and the reason they're responding, whether they're responding code 3, lights and sirens, or not. I would say it can, but I'm not aware of any facts and circumstances that would apply in this case.
So in this particular case, after Officers King and Lane initially responded to the call, dispatch sent Officer Chauvin and Officer Tao code 3 to the scene. You don't recall that?
I would have to review the materials, but again, I'll accept your representation of that.
And ultimately, it was then because they were taking somebody out of the car, correct? Implying that a reasonable officer would know that someone was being removed from the car for some reason, right?
Yes,
And
I recall that now. Thank you.
And an officer would have that, a reasonable officer, if we can take what they would know before the use of force into consideration, would know that fact.
Yes, a reasonable officer would have known that at some point prior, officers removed Mr. Floyd from the vehicle,
and
from a vehicle.
One of the factors that you discussed in terms of the Graham v. Connor standard was the severity of the crime they were responding to, right?
Yes.
And ultimately, in terms of that, do reasonable police officers frequently encounter a situation that starts out as a mild offense, but elevates to something more serious?
It's certainly possible. I don't think there's any reason to suggest that there were facts or circumstances of that here.
Well, if the officers who were initially on scene were struggling with an individual, resulting in dispatch stepping up 2 additional officers code 3, that would at least imply that there was something more serious than just a counterfeiting, correct?
No, not necessarily. In this case, they were taking Mr. Floyd out of the vehicle for the counterfeiting.
Resulting in a dispatcher stepping up the call to code 3.
Yes.
And so again, reasonable police officers, in addition to relying on their training, provided it meets professional standards, they also can rely on their experience, as right.
With the same caveats, yes. Yes.
Provided that those prior experiences meet with professional standards.
Right. Again, there's a difference between what an officer is relying on and whether their behavior meets the generally accepted police practices.
And so one of those types of issues that a police officer may have experienced is perhaps people don't like to be arrested, right?
That is not uncommon.
Right. And that people who are being arrested sometimes feign illness or feign some medical emergency in order to avoid being arrested. Agreed?
So officers would know that when they get someone medical attention and it turns out that a qualified medical provider can say there's nothing here.
Or that the person's, behaviors change, right? They say, I'm having a heart attack, but then their behaviors are inconsistent with their words. They start doing jumping jacks or something.
I've never seen that.
So it's also, again, based on an officer's experience. It would be reasonable police officers may experience one suspect in a car disrupting the police intervention to assist other people in the car from avoiding apprehension. Have you seen that?
What? I'm sorry, can you ask that again?
Sure. There would be, again, based on a reasonable police officer standards or a reasonable police officer's experience, that one person who's being detained by police may obstruct that police intervention to sort of protect or hide information about his or her passengers.
That the individual who is being detained may
resist or obstruct in order to prevent his or her friends from being searched or identified.
I suppose, at least in theory, that's possible. In this case, it's not clear that a reasonable officer in the defendant's position would have been aware that there were passengers.
Well, did you said you've spent 120 to 130 hours reviewing the body cameras, correct?
Yeah, something like that.
And you are aware where Officer Chauvin,
and the rest of the materials, of course.
And you're aware of where Officer Chauvin and Officer Towle parked their vehicle, right?
Yes.
And you were aware, based on the materials, that an additional squad car was there from the Minneapolis Park Police, correct?
Yes.
And that officer, where they were parked, was essentially across the street from each other at the point that Officer Chauvin arrived. Agreed?
Yes, there were several cars on that street. What I'm saying is I'm not sure what a reasonable officer in Officer Chauvin's position would have known about events that occurred on scene prior to his arrival.
He would know that other officers also responded, correct?
Yes.
And based on the dispatch, we know that Squad 830 from the Minneapolis Park Police arrived.
Yes.
Right? And when he arrived, he would be able to look across the street, see that park police officer engaged with and doing whatever he's doing, presumably.
Presumably, if he looked across the street and saw that, I don't know what the officer was doing at the time or what.
An officer has to be attuned to his or her circumstances and surroundings. Agreed?
Yes.
A reasonable police officer has to have a particular situational awareness, right?
Yeah, yes, I wouldn't say a particular one. I would say a general situational awareness. Absolutely.
Right. And so when Officer Chauvin arrived, if he parked directly across the street from another squad car and was aware based on dispatch that another squad car was in fact present, a reasonable officer would be generally aware of what all officers are doing, right?
No, a reasonable officer who arrives without more specific information would not know whether that park police officer is talking to other witnesses about the counterfeiting call or other suspects or passengers in the vehicle that Mr. Floyd was taken out of. Just seeing an officer interact with someone does not provide nearly enough context to understand, well, the context of that interaction.
And so a reasonable officer would never take into consideration that other officer, even if it were another citizen, in terms of, again, the use of force, that other officer becomes unavailable to assist him based on what he or she is doing.
Objection. Handcuff on.
Overruled.
The officer would, I'm sorry, can you ask that again, please?
A reasonable police officer arrives on scene, right? He looks to his left and he sees an officer talking to two citizens. Looks to his right and he sees two officers struggling with an individual, or having a point of contention, I believe you called it, with an individual, right?
At the point where he arrived, I wouldn't call him struggling, but yes.
Right. But he observes that there's obviously something that's a little bit more serious going on here, right?
Yes, at least they have one individual in custody there or in handcuffs, yes.
Right. And the reasonable police officer would know that that other officer who's all the way across the street is not going to be as much of an assistance as he could potentially be as he's approaching the.
Yes, if I understand your question, yes, as the officer arrives there, he is in a better position to offer immediate assistance to the officers interacting with the handcuffed individual than an officer who is talking to whomever.
And a reasonable police officer will assess a person's words in the context of their actions. Agreed?
I would say assess both their words and their actions, yes.
And if someone is saying, I'm going to cooperate, I'm going to cooperate, I'm going to cooperate, that's what they're saying, their words are saying, but their actions are not cooperative, right? What is an officer to do in that situation? Just automatically believe that they're going to sometime cooperate?
I think it depends on the situation. No, I don't think an officer has to assume that this person will, at some future point, comply.
And in fact, an officer, again, is entitled to use force under these national standards greater than the force or greater than to overcome the suspect's actions. Agreed?
So I really don't like greater. Sometimes I hear that formulation, but it doesn't make a lot of sense to me. If someone is running away, what is force greater than running away? I would say that an officer has to use or can use force that is proportional and reasonable to address an individual's non-compliance or resistance, assuming, of course, that they have legal authority to do so.
Right. And how it is frequently described in these materials that you've reviewed is that an officer can use an amount of force that is greater than the force being used by the suspect in an effort to overcome that resistance, right?
Are you asking me about the MPD training material specifically?
Yes.
Objection, Your Honor, beyond the scope.
Sidebar.
A reasonable officer is should be permitted to rely on information that they receive from his or her partner officers, correct?
Yes.
And do you recall in reviewing the video after or as this struggle was ensuing, Officer Chauvin asking if he was under arrest?
I do. I believe that's either prior to or as they're taking him out of the vehicle, out of the police vehicle.
And other officers confirmed that he was under arrest at that time, correct?
Yes, either Officer King or Officer Lane says, well, he's under arrest for forgery, or again, something very similar to that.
Right. And Mr. Floyd said forgery for what, right?
Yeah, something like that.
And so in the context of this particular case, a reasonable police officer decide if the suspect should be put into the squad car, or does the suspect decide whether they should be put into the squad car?
The officer determines that someone should be put into the squad, again, assuming there's legal authority and the like.
Right. And so, assuming that there's legal authority, the suspect does not get to dictate, do I get to sit on the ground or do I have to sit in the squad car? Agreed?
To some extent, yes, absolutely. There's yes.
Now, as we watch through the clips that you selected, the clips that we watched were not chronological necessarily in their order, were they?
Going in sort of top row and bottom row, each was chronological, right? The first clip happened first, the last clip happened last, and then we went back to the beginning on the bottom part, right, on the foreseeable effects discussion.
Reasonable officer would also presumably have some knowledge about his partners, correct?
You might need to define some knowledge, but they would certainly know some stuff about the other officers that they were interacting with at close proximity, yes.
A reasonable officer may know that these other officers who are on scene were on their second or third day as police officers.
Overruled. It depends what the officer knows at that point. If those are facts and circumstances that they are aware of, then a reasonable officer would be aware of it. Yes, it's entirely possible for an officer to not to work with an officer in the field that they don't know how long they've been on the field.
Now, you testified on direct examination that a reasonable officer would, when they approached and saw what was happening with Mr. Floyd, would know that, for example, that person had been searched, right?
I believe I said that it would certainly suggest that someone has been searched, because you don't generally load someone into a vehicle before they had been searched.
But you don't know if the search was, that reasonable officer would not necessarily know if the search was thorough, correct? Because they didn't see it.
As you pointed out, officers are allowed to rely on the information that they get from other officers. So while no, the officer is not in a position to gauge how thorough the particular search was, there is an element of relying on other officers to do the job they've been trained for.
And also in terms of, you don't know whether the vehicle that the person and or his occupants was in was searched. A reasonable officer wouldn't necessarily know that at that point.
Yes, that's correct. Without additional information, I don't know why a reasonable officer would know that a vehicle had or had not been searched, or had or did not have occupants.
But in fact, during the course of their interaction with Mr. Floyd, the officers did in fact discuss that Park Police was over with the occupants of the vehicle, and that the vehicle hadn't been searched yet, right?
At which point?
As they had Mr. Floyd restrained.
I can't tell you exactly when that happened. I remember some discussion to that effect.
So officers, you would agree they go through this process of reassessment, the reasonable police officer does, right?
I certainly hope so, yes.
And officers will get information that may change how to deal with a particular situation, right?
Yes, as officers get additional information, they may update their response, escalating or de-escalating a use of force, for example, or talking to one person or not talking to one person that they had originally intended to speak to. Sure.
Now, in terms of, again, the concept of situational awareness, an officer has to be aware of his or her surroundings, agreed?
Yes.
And that would include things like being on a busy street, right?
Yes, tactically, that's why you don't want to prone someone out on a street when you have the option of not doing so.
In terms of those tactics, however, when Mr. Floyd, so I want to make sure that we're very clear here, in your position, from your review of the reasonableness of the use of force, it was unreasonable for the officers to put Mr. Floyd in the prone position at all, period, correct?
Yes, at that point, he did not present a threat to the officers or their interests. He did not present a threat of escape. The officers used some amount of force to put him into the car, and I have no issue with that. But putting him in the prone position, especially on the street side of the car, was unreasonable and excessive and contrary to generally accepted police practices.
Reasonable minds can disagree. Agreed?
On this particular point, no.
Okay, so Sergeant Steiger, who testified earlier, did you have an opportunity to review his testimony?
I believe yes, I did.
And so his assessment that it was reasonable for the officers to use the prone position in that time, at that time, you would disagree with him?
I disagree. I think putting someone prone is unreasonable there. They are already handcuffed. The prone position is a transitory position used to restrain someone, handcuffs, or I suppose hobbles. In this case, officers took Mr. Floyd out of the car, put him on his knees, and then put him onto his side. And again, if they had stopped there, I would not have any quibble with their actions.
Now, you testified that you described the prone position as transitory in nature.
It is, yes, for 30 years or so, it's been generally accepted that that is a transitory position for the purposes of handcuffing or securing.
Are there ever situations where officers would keep a person in the prone position longer than a transitory nature?
There shouldn't be. The putting someone in the recovery position is literally a matter of rotating them 90 degrees onto their side. Officers can maintain as much or almost as much control over the individual. So while I suppose it's hypothetically possible, you know, if there's, I don't know, if gunfire breaks out and the officers are laying on someone to protect them with their body, maybe, but certainly not in this case.
So in your academic endeavors, you submitted a opinion piece to the Washington Post. Do you recall that?
Specific to this case, I don't know, close to 30 op-eds at this point. So
on May 29th of 2020, an article appeared in the Washington Post authored by Seth Stoughton. That's you, right?
Stoughton, but
Stoughton,
yes.
sorry.
That's all right.
Jeffrey Noble, that's the person you wrote the book with, right?
Yes, one of the two individuals.
Yep, and Jeffrey Alpert, right?
The other co-author of the book, yes.
And so you wrote officers might need to hold someone down in the prone position, but they should do so by putting their shin across the subject's upper back, not the neck. Do you disagree with that?
Objection, Your Honor. Hearsay.
Overruled.
Are you asking me if I wrote that?
Correct.
I did, yes, referring to handcuffing.
Pressing on someone's neck risks damaging the cervical spine or breaking the hyoid bone, which can be fatal.
Yes.
And this was an opinion that you had formulated. Your opinion piece was from 4 days after this incident?
That, yes, it was based on the review, as I think I write in the first or second paragraph, the opinion, the limited information that was available at that time.
Right. And so at that point, it's fair to say that you had already formed the opinion based on that limited information that this was an unreasonable use of force.
I think it's fair to say that I had formed the opinion that putting your knee across someone's neck, except in absolutely unbelievably rare circumstances, is generally an inappropriate use of force. This is an application of that generally accepted practice. Of course, as I reviewed all of the materials in this case, some of the opinions that I discussed at the bottom of that op-ed changed, and this was not one of them. The additional information confirmed that the knee across the neck was inappropriate and that the prone restraint was inappropriate.
Was the knee, in your opinion, across the neck throughout the entire 9 minutes and 29 seconds?
From my perspective, that's irrelevant. The knee should never be on the neck. It was certainly on the neck for a majority of the time, even if it was moved off of the neck at certain points.
Were you able to somehow determine the amount of pressure that was applied to Mr. Floyd's neck?
Not with any specificity, of course. There are some indicators that it was a substantial amount of body weight, but I can't tell you exactly how many pounds. For example, the positioning of the defendant's hips forward and over the left leg, the position of the defendant's shoulders, as opposed to being back in sort of a squat position where you'd be resting on your feet. It was forward, indicating more weight on the front towards the knee.
And at times it was to the right, correct?
Yeah, I think his hips, or not his hips, excuse me, his right shoulder dipped at some point. I'm unable to say what effect that had on the weight on his left knee.
So let's go back to the period of time when the officers were attempting to put Mr. Floyd into the squad car. Reasonable police officers, again, in assessing their use of force, have to take into consideration the strength of the individual, right?
Yeah, sure.
Based on the experience that they may just have had, right?
How strong someone is a reflection of their physical ability to resist in different ways. So that is certainly a factor in that threat analysis.
And you already testified that a reasonable police officer can take into account size differences. Agreed?
Size differences, number of officers versus number of subjects, physical characteristics, age. You know,
a 10-year-old versus a 40-year-old may present a different threat or risk analysis. Agreed?
Yes, they have different levels of physical ability, the threat that they present, or the severity of the threat they present, even in doing the same actions, right? A healthy college student and a morbidly obese 90-year-old are not going to throw the same punch.
Reasonable police officers do take into consideration an expected, perhaps EMS response, right?
In what context?
Time.
I'm sorry, in making which decision? Yes, absolutely. Reasonable police officer. I mean, when you call EMS, you expect EMS to respond. So certainly officers can act in reliance that EMS will respond when called.
Right. And you understand that in this particular case, EMS was called
Yes.
And that was contemporaneous to the point of the discussion about the use of the MRT, correct?
Yes, I forget if that's when they were initially called or when they were upgraded, but yes, somewhere in there.
And again, a reasonable police officer in assessing the physical condition of the suspect, it would be reasonable for him to increase the response of EMS based on those observations, right?
To upgrade it, to ask for a lights and siren response. Yes, absolutely. What's not reasonable is
objection non-responsive at that point.
The answer is concluded at that point.
A reasonable officer has to take into consideration his or her position relevant to other bystanders, right? I mean, meaning if a police officer's on the knees and there's a crowd of people that are standing above them, that's a consideration that a reasonable police officer would make.
Depending on the situation, that can affect a concept that's referred to as reactionary gap. It's one of many such factors in this totality of the circumstances. So if there is some reason to believe that the crowd is threatening in some way, yeah, absolutely. I don't see that the case here.
You've seen obviously the footage, and at one point you observe Officer Chauvin reach for his mace, correct?
Yes.
And shake it?
He takes it out of the holster, and I forget if he shakes it, but he definitely has it deployed, yes.
While saying to the crowd, don't come over here.
Or something like that, yes.
Reasonable police officer would know that they are being recorded, right? In this situation.
I mean, the officers are wearing body cameras, so they should know that they're being recorded.
And based upon your review, it appears that several people are standing right out in front of the officers holding what appear to be cell phones, correct?
Oh, yes.
And a reasonable police officer who is situationally aware, would be aware that they are being recorded by the bystanders.
I think that's a fair description depending on the positioning of the officers. I'm not sure a reasonable officer in Officer Lane's position at Mr. Floyd's feet would have been aware, but in the defendant's position, yes.
And you're familiar with the concept that sometimes situations may look awful, but they may be lawful.
With the concept? I suppose can you explain what you mean there, please?
Sure. The police use of force is never a particularly attractive thing to watch or to witness.
It's not very pretty. Yeah, I think that's often the case.
Right. And just because it's not very pretty does not mean that it's not lawful use of force. Agreed?
Yes, sure. An officer can act reasonably and consistent with generally accepted police practices, and it can look bad. As I said, I don't think that's the case here.
Based on the standards that you're aware of, prone control of a subject versus prone handcuffing, are those two different police practices?
There is a significant difference between the positioning and the techniques of getting someone into handcuffs, and then the techniques and tactics of maintaining control of someone once they've been handcuffed. So if that's what you're asking, yes, the actions that an officer takes while handcuffing someone are not necessarily justified after the individual has been handcuffed.
You're aware of the general concept of a use of force continuum, correct?
Oh, yes.
And that a use of force continuum may include also what is called passive resistance. Agreed?
The resistance portion of the use of force continuum can include what we can call passive resistance. Absolutely.
And passive resistance does not exclude the possibility of the use of force.
That's correct. So to go back to my previous example, if you have someone who is laying across a driveway, for example, protesting whatever happens on the other side of the driveway, the officer may use force to address that passive resistance to move that person, sure. Again, there has to be a threat that they're addressing with that passive resistance.
So in terms of the, at the point Mr. Floyd is placed prone on the ground, do you observe him continue to kick his back legs?
Or he's brought down to the ground?
Yep, initially.
So there's one movement that's captured on, I believe, Officer King's and Officer Tao's body cameras that looks to me as if Officer Lane is grabbing Mr. Floyd's leg and pulling it and straightening it and rotating it. That is my interpretation of what is happening there.
And in fact, at that particular point, Officer Lane says something to the effect of Jesus Christ.
I don't remember if it's at that particular point. Yes, it's not clear to me what he's referring to. He later makes some comments about what appear to be the smell of Mr. Floyd's feet. So I'm not sure what he's responding to when he says that.
So you did not observe him attempt to control Mr. Floyd's legs at that particular point?
Oh no, he was definitely controlling Mr. Floyd's legs at that point. When the officers bring Mr. Floyd from his knees onto his side, and then from his side into that prone position, that grabbing and what I see as pulling the leg is part of controlling the leg to flip Mr. Floyd's hip and put him into that prone position, at which point Officer Lane kneels over and then later holds Mr. Floyd's leg. So yeah, he was definitely controlling his legs.
Now, you would agree that a reasonable police officer has to assess multiple situations simultaneously, agreed?
No, a reasonable officer has to assess the situation that they're in. Certainly there are simultaneous inputs to that, but they're in the situation that they should be focused on.
So a reasonable officer who's in a situation where they've just struggled with, three officers have just struggled with an individual, they're going to have some sense of exhaustion themselves, agreed?
Depending on the length of the struggle and their efforts in the struggle, in this case, it was relatively abbreviated.
They would have to take into consideration the changing circumstances throughout the use of force, agreed?
Absolutely, they need to take into account changing circumstances.
And you were shown some footage of the crowd that was present or that formed initially was a relatively small crowd, agreed?
Yes, I mean, personally, I wouldn't describe it as a crowd. It was like 12 to 15 people, including folks over by the bus stop. So a group of bystanders.
People across the street as well, right?
There was at least one person filming from across the street. I don't remember seeing many bystanders on the other bystanders' cameras.
Okay. You agree that the camera only captures what the lens captures, right?
Any individual camera? Yes, any individual camera will only capture what's on camera.
And so, for example, that city poll camera, the milestone camera, you can see other individuals standing, more than one individual standing on the sidewalk across the street from where the officers were positioned. Agreed?
Yes, at times, yes.
And at various points, you would agree that there were people across the street to the southeast, excuse me.
Is that the Dragon Walk restaurant?
Correct.
Yeah. Yes, I believe the park police officer remained over in that way, in that direction.
With you know to be two other passengers who were in the vehicle, at least, correct?
I do, yes.
And also, I know that, but they're standing there. So officers who are in the scene, a reasonable officer is assessing not just what's in front of him in terms of the subject, but they're assessing, does this group of people present a threat or a risk to me?
Yeah, that's the basics of situational awareness, right? Knowing, not getting so focused on one particular thing that you lose awareness of the broader situation, the context in which you're acting, excuse me.
Yep. And again, a reasonable officer in terms of situational awareness will try to be aware of what's behind him. Agreed?
Yes.
Or to his right or left.
The surrounding situations, yes.
And reasonable officers can be distracted by those types of things.
So depending on what those other stimuli are, yes. In this case, the first, again, more than 3.5 minutes, there's no criticism from any bystanders. There's either silent bystanders or, in the case of Mr. McMillan, bystanders who were urging Mr. Floyd to comply with the officers.
There was also radio traffic, agreed?
Some amount of radio traffic, yes.
Confirming at one point at least that EMS was en route, code 3.
Yes, that was, I think, relatively late in the interaction, but yes. Or confirming that they were at a particular location.
It was at the particular time. We watched a couple of seconds as they were discussing whether Mr. Floyd was using some sort of controlled substances. Would you agree with that?
Yeah, so yes, I do.
A reasonable officer has to take into consideration, as you testified, that the suspect may be under the influence of a controlled substance, right?
Absolutely.
And a reasonable officer, based on nationally accepted standards, you testified has a duty of care in that particular situation, right?
In the situation where someone is potentially under the influence of controlled substances?
Yes.
So my testimony was an officer certainly has a duty to render medical aid as appropriate. Just because someone might be on drugs doesn't necessarily create a medical situation, but it certainly affects their susceptibility to positional asphyxia, which officers should take into account.
And a reasonable police officer, in terms of his or her belief that someone may be under the influence of a controlled substance, can take into account that that person may be stronger than they would normally.
In terms of assessing the potential physical ability of the individual, yes, that of course doesn't play into the opportunity or the apparent intention prong of threat.
You would agree that reasonable police officers should have a higher level of awareness than non-law enforcement officers?
I think the nature of the job makes that a really good idea, yes.
When you take into account the reasonableness of the use of force, you would agree that you're not actually experiencing what the officers felt at that point, right?
That I individually am not experiencing it? No, I am applying the reasonable officer on the scene framework. I am not, in fact, there.
Right. And so you don't have the same sensory responses to what the suspect or the officers are doing, right? You would not know, for example, is this person tensing his or her muscles? Because you're not feeling or touching that person.
Yeah, so tactile feedback is one of the things that may not show up on video. It might, but it does not always show up on video. That's correct.
When you do your use of force analysis, you're not doing it in a dangerous environment, I presume.
Without making any jokes about my kids, no, I'm not generally doing it in an extant dangerous situation.
You have the luxury of slow motion, enhancements, looking at things from multiple perspectives. Agreed?
Overall.
So for the portion of the inquiry where for the portion of the inquiry where I'm identifying what the underlying facts were, yes, I can slow video down, I can freeze frame it. As I am taking those facts and circumstances and identifying what a reasonable officer would have perceived in that situation, I'm of course aware that a reasonable officer on the scene does not have those capabilities.
Now, you also described repeatedly seeing what you believed to be Mr. Chauvin's knee on the neck of Mr. Floyd, and you described that as deadly force. Agreed?
Yes.
And you're trained in prone handcuffing and prone control yourself, correct?
Yes, I suppose.
And in terms of an officer's training to use prone control, as you describe in the Washington Post article, the knee should be in the back between the trapezius muscles. Agreed?
Trapezius, shoulder blade, tricep area, lat, the big muscle under here. Yes.
And that would not be considered the use of deadly force. Agreed?
If again kept transitory, so that we aren't turning that into a prolonged prone restraint, then no, that would not be considered deadly force.
Reasonable police officer, based on national training standards, would take into consideration the prospect that a person who fights with them and then appears to be compliant could potentially become a threat again.
So what you're describing is risk, right? The idea that they could potentially become a threat, that's the very definition of risk. Yes, and officers can do a range of things to mitigate risk and to prevent it from becoming to prevent it from becoming a threat. They can't use force to address risk.
But they can use some degree of force to deal with passive resistance.
Yes, they can use some degree of force to address passive resistance. Passive resistance does not present, of course, a threat of escape or harm to the officers. And it's the type of situation where if someone is passively resisting while officers are just trying to maintain control over them.
It's not a reasonable officer would never expect that person to get up and run away or become a threat again?
That's not my testimony. My testimony is there may be some risk of that, but officers can generally maintain control over a handcuffed individual in the side recovery position, which is what it's designed for.
You also watched one of the clips where one of the officers checked for a pulse, correct?
Yes.
And you heard Officer Chauvin say, huh?
Yes.
And then the response was, I'm just looking for a pulse.
It was something like that. I said I was checking for a pulse, or said I was looking for a pulse, or something like that.
At the point that the officer references, we didn't watch the entirety of it during this clip, but at the point the officer references that he was passing out, you also hear officer say, but he's still breathing.
Yes. At that point, he was still breathing. Or at least the officers are narrating that he was still breathing at that point.
I have no further questions, Your Honor.
Redirect.
Thank you, Your Honor. Sir, you were asked some questions, and I'd like you to provide some further explanation regarding using more force than the subject presents. Right? And I believe you were asked if the officer was allowed to use sort of a level up of force. Is that an oversimplification of the reasonableness standard?
Yes, it is. And it's an oversimplification that really doesn't make a lot of sense, right? Like I said, what does it mean to use a level up from passive resistance or someone running away? You know, running faster doesn't count. So I don't find that to be a helpful formulation of explaining proportionality and reasonableness.
And you also testified as to the need for officers to reassess the situation on cross-examination. Is that right?
Yes, absolutely.
Be situationally aware of changes in circumstances. Is that right?
Yes, absolutely.
And that, you know, some officer may need to be aware who's behind them across the street at some point. Is that right?
Sure. Officers should maintain that level of situational awareness.
But should a reasonable officer maintain a level of situation awareness as to what's going on right in front of them?
Absolutely. That's still the primary focus. Situational awareness is not exclusively focusing on what you're dealing with right in front of you, but it's also not ignoring what you're dealing with and that's right in front of you.
And with respect to tactile response, that's feeling the response of someone who you're touching. Is that right?
That's correct. So someone who's, you know, you can't just tell looking whether I'm pushing on my own hand. So yes, that's correct.
Would a reasonable officer in the place of the defendant then have the situational awareness to understand that he's kneeling on top of a limp person who is not responsive?
I would certainly have hoped so. Yes, a reasonable officer would absolutely be aware of that.
And in terms of situational awareness and relying on information provided from partner officers, would a reasonable officer in the defendant's situation have paid attention when the comment that they couldn't find a pulse was made?
Yes, absolutely. That's an incredibly important piece of information for an officer there, as is the moving of the individual. One of the things that we know about positional asphyxia is this concept of vicious cycle, which is that as someone starts to have difficulty breathing, they move or resist, if you like, for breath. They're fighting to breathe, not fighting officers. And again, this goes back almost 30 years as generally accepted with regard to positional asphyxia and the way officers should address it.
In terms of rendering medical aid and the decision of an officer to believe if someone is stating something like, for example, I can't breathe, shouldn't the officer using situational awareness determine the credibility of that statement based on all the facts and circumstances presented at the time?
Yes, and again, the officer has very limited ability to engage in credibility determinations there. So if someone is expressing difficulty breathing, you roll them onto their side so it's easier for them to breathe. That is what the side recovery position was intended for.
One hypothetical situation is that a person standing in the distance from me to you, speaking in the tone that I'm speaking, expressing to you that I can't breathe, you might have a reason to doubt that based on all of the facts and circumstances, correct?
Sure. Under our yes, under our interactions, there's no reason to believe that that's the case. There's no behavioral indications. We're continuing to have the same conversation. As the officer, I would still want to take that seriously and potentially summon medical aid, but we're not in the position of me, knocking you down and doing CPR or anything.
But if you're kneeling on top of me and I'm telling you that you can't breathe, that might be a different situation. And your situational awareness might prompt you to believe that, in fact, what I'm saying is what I'm actually experiencing. What would the situation be? Well, never mind. I have no further questions.
Any further recross? Thank you, sir. You are excused.
Thank you.
Members of the jury, we will be taking our adjournment for the day, but I wanted to give you an idea of a little bit of time frame now that we're getting closer to the end. We expect that we'll be moving to the defense case tomorrow. And accordingly, we expect that we'll finish all the evidence in this case by the end of the week, possibly with even Friday off. My preference is not to make the attorneys close on Friday because when they close, this case will be submitted to you for deliberation, which means at that time, as we warned you long ago in jury selection, you'll be sequestered. If I were to have closing arguments on Friday, that would mean you'd be sequestered in your weekend. And I don't know if you have any plans. I'm not going to do that. My preference is to give the attorneys more time to prepare their closing arguments and have the closing arguments, we predict, on Monday. At that point, you will be sequestered. So you'll get some more information from the sheriff's deputies regarding that, but expect that you will, when you report for duty on Monday, that it will be followed by sequestration. So pack a bag. But the deputies will give you a little more information. Just wanted to kind of give you that so you can plan your own lives around that. And we will see you tomorrow about 9:15. Thank you. We're in recess.